Test, test, test. Madam Recording Secretary, please start the meeting.
The meeting is started.
Thank you. Good evening, everyone. I would like to call the February 8, 2024 Santa Ana Police Oversight Commission regular meeting to order. The time is 5:05 p.m. This meeting is taking place with in-person attendance at City Hall in the council chamber. The public can also watch the meeting online via the Santa Ana YouTube channel or the city's website. Madam Recording Secretary, can you please conduct a roll call?
Thank you, Chair Vega. Commissioner Castillo-Lawton.
Here.
Commissioner Goransky.
Here.
Commissioner Mejia.
Present.
Commissioner Perea.
Present.
Commissioner Said.
Here, thank you.
Vice Chair Carpenter.
Here, thank you.
Chair Vega.
Present. We now move on to the Pledge of Allegiance. Vice Chair Carpenter, would you do us the honors, please?
Yes, sir.
Thank you, Vice Chair. Now moving on to public comments. Now is the time for the commission to receive comments from the public on agenda and non-agenda items. Pursuant to the Brown Act, the commission may not enter into discussion at this time. Speakers will have 3 minutes for their comments. Madam Recording Secretary, is there anyone who wishes to speak in person?
Chair Vega, yes, we do. Bomaro Vicente, will you please come to the podium? Okay, you do have 3 minutes to speak.
Okay, I thought it was 2, so that's great. Hello, Commission. My name is Bulmaro Vicente, but folks call me Boomer. I'm a lifelong resident of Santa Ana, and I'm the Political and Policy Director for Chispa. I am also a former Police Oversight Commissioner for the City of Berkeley, which that experience actually led me to come back home to Santa Ana and help write this city's police oversight ordinance through Chispa, along with community partners and organizations. And today, I'm here to express my concern with a training beat hosted by James R. Touchstone, who currently serves as a general counsel for the California State Sheriff's Association, California Police Chiefs Association, and the California Peace Officers Association. You know, these organizations are known to shield officers from accountability, lobby the state legislature against police reform, and actively obstruct the implementation of state law pertaining to police reform. For instance, all 3 associations opposed SB 2, a bill that created a statewide process to revoke a professional certificate issued to officers for serious misconduct. Moreover, CPCA's lobbyists opposed AB 392 before it was signed into law. And AB 392 actually raised the standard for when police can use deadly force from reasonable to necessary. We're troubled by the choice of an attorney representing these police associations to train a commission entrusted with independent oversight and making recommendations on critical issues like police misconduct. As a body entrusted with powers like making discipline recommendations on misconduct cases, it's imperative that the commission operates with the utmost fairness and impartiality. Collaborating with an attorney who represents law enforcement associations violates the spirit and intention of this commission. The ordinance itself emphasizes that training, quote, should be predominantly obtained from independent third bodies or institutions that have experience with internal affairs of police departments and civilian review investigations and audits, period, quote. There are various credible organizations such as the ACLU of Southern California and the National Associations of Civilian Oversight of Law Enforcement that could provide suitable alternative trainings for this commission. For example, when I was on the Police Oversight Commission at Berkeley, we received training from ACLU professionals. So given these concerns, we urge the city staff to consider alternative trainers who can facilitate the required training sessions in a manner consistent with this commission's objectives and impartiality. Lastly, I asked if the commission can open up the intake process for people to submit complaints, even anonymously. Even if the commission isn't fully trained yet, people are experiencing
You
misconduct
have 10
and should be
seconds
able
left.
to file a complaint in the meantime. Thank you.
Thank you for your comment.
Chair Vega, that concludes the public speakers. Noting for the record the e-comments received, 1 comments regarding agenda number 2 regarding the selection of the entity.
Thank you. We now move on to the consent calendar. Item 1 is the minutes from the January 11, 2024 Police Oversight Commission meeting. The recommended action is to approve the minutes. Would any commissioner like to make a motion to approve the minutes of that meeting?
I'll approve. Keith Carpenter.
Motion by Vice Chair Carpenter,
I'll second.
seconded by Commissioner Castillo-Lawton. Madam Recording Secretary, can you please conduct roll call?
Motion to approve the minutes moved by Vice Chair Carpenter, seconded by Commissioner Castillo-Lawton. Commissioner Castillo-Lawton.
Yes.
Commissioner Goransky. Commissioner Mejia.
Yes.
Commissioner Perea.
Yes.
Commissioner Said.
Yes, thank you.
Vice Chair Carpenter.
Yes.
Chair Vega.
Yes.
Motion approved by unanimous consent.
Great, that is the end of the consent calendar, and moving on to the business calendar.
We had one more public comment, right? Should that have been read out loud, the email?
Thank you, Chair Mejia, or excuse me, Commissioner Mejia. We don't read the e-comments that are received, but the recording secretary did provide a brief summary of the 1 e-comment that was received, and you each received a printed copy of that email that came in earlier this afternoon, and there is a copy of that email that is available for public inspection in the lobby here in the council chamber.
Okay, so we move on to item 2 in the business calendar is training on constitutional legal foundations for potential violations of the Constitution, legal considerations regarding use of force standards, use of force statistics, and related topics. Mr. Touchstone?
Actually, I have a comment on that. Can we have a discussion before that?
Can I see clarification on that? Can we have discussion prior to the item?
Chair Vega, if you'd like, you're more than welcome to entertain questions or comments from the members of the commission before you receive the staff presentation.
Okay, sure.
Yeah, I would like clarification on how the training was, or the person being training us was selected, if I can get more information on that first, and then I have a second question.
Yes, Commissioner, I can speak to that. Mr. Touchstone has extensive experience with our office in providing assistance with outside counsel matters. His resume will speak to the fact that he is very experienced with all matters related to law enforcement, POBAR, civil rights, these types of issues, the exact types of issues that he's going to speak to tonight. And he is known to our office, and we selected him because we believed him to be a very neutral, impartial, and qualified speaker to speak to these topics. I would further add and just remind that we are also in the process of finalizing an agreement with Nicole, the entity upon which the speaker recently spoke to. So we will be finalizing an agreement with them to be providing additional training. So this is going to be a very comprehensive and kind of overlapping series of trainings from different entities whom people may think have different perspectives. I can assure this body that these entities have been vetted, and we believe that this is going to be a very robust and substantive training that will not take on bias forms or bias shapes, that this is going to be a training that will be beneficial and is not in any way slanted towards one way or another.
Yeah, thank you for clarifying that, and I completely understand that portion. However, I would like to push back on that because nothing is really impartial, right? Like, realistically. It's also concerning, and I want to appreciate Boomer's comment as well as Maria's comment on the email, is that given Mr. Touchstone's background litigation, it is actually quite very problematic because I'm not dismissing that you are an expert in this subject matter. You are. However, what I'm concerned about is that our role is to have police oversight accountability. In giving someone the ability to train the commission on litigation, on someone who's defending the very much folks we want to have accountability for, is troubling and concerning. And so for me, as someone who's in the commission, and I want to make sure that we are having the best training and to our ability, I don't think Mr. Touchstone is the most impartial person to do that, especially given the use of force of how, as we know, not everything that's legal is just, right? People can justify certain actions, and having someone who comes from a background who actually supports and defends law enforcement on this matter, how can we have the proper training to hold the Santa Ana PD accountable when we are being taught and trained in a very skewed way? So I would actually push back that this is not neutral at all. And I would like the commission to rethink whether we want to have this training by Mr. Touchstone. And if everyone agrees that this is a case, even if I disagree, then I can understand. But if that is the case, then I want to propose that then we have someone else also touching on the use of force, given how problematic this has been. And the main reason, right, why there's a lot of complaints is because of the use of force. So again, I am not critiquing that you do not have the expertise in the subject matter, but rather that it is biased.
Thank you for your comments, Commissioner. Mr. Soto, can you confirm if Nicole will be touching on use of force? I believe that they are, but can we just confirm that with the draft agreement?
I recall that use of force topic is included in the draft scope of work that we are requesting Nicole to present and train the commission on at a future meeting. Yes.
Can I make a comment?
Sure, go ahead.
Can we allow Mr. Touchstone to address some of these concerns or to respond?
He may, if he wishes to. Mr. Touchstone?
Sure, I'm happy to, and I appreciate everyone's comments, and I want to encourage you to get training from a variety of sources. I've been an attorney for 28 years. 27 years of that I've been representing law enforcement. I've been general counsel to the associations that the gentleman alluded to since 2017. That being said, my law firm also represents management in disciplining police officers, terminating them for violating policies. We've been doing that for the last 35 years. That's one aspect that wasn't necessarily mentioned in the training. And also, from the perspective of the training you're going to receive today, I'm going to talk to you about the law. I'm not going to give you my opinions on it. I'm simply going to tell you what the law is. You can form your own conclusions and obviously exercise your own judgment when matters come before you that you are tasked with reviewing and making recommendations to the chief of police. So I'm just going to kind of go through the law, black letter, as we say in the field. And again, how that gets applied, that is totally your prerogative. And like I said, I welcome different aspects and opinions from anyone that you get before you, so long as they have some qualifications and some expertise in the area. Fantastic. Get different viewpoints. However, I don't think any training that comes before you should usurp your role as ultimately the decision makers in making recommendations on these various issues. I trust you've all seen a copy of my PowerPoint. I don't think that it is biased in any way. It's simply going through what the law says. I'm not giving you any varnish conclusions about how you should apply it and this, that, and the other. That's not my role here today, folks. I'm just telling you what use of force law is, much like if you were sitting as jurors in either state or federal court, which are right around us here, you would get jury instructions at the conclusion of a trial, and you would be tasked with making the decision as to how that law should be applied given the circumstances in front of you. So hopefully that addresses your concerns. I'm not here to sway you one way or the other.
Thank you, Mr. Touchstone. Please proceed with the training.
Okay, fantastic.
Go ahead.
Assistant City Attorney, I have a question. What's the timeline for the agreement to be finalized with Nicole?
I'm sorry, did you say what, the timeline for the agreement to be finalized? So we will probably be getting the draft form of the agreement back to Nicole within the next couple of days, by early next week at the latest. And then at that point, it's on their end to review and execute and send back. But once that happens, it would be imminent. I will say that there were terms, just procedural stuff with the agreement that we've gone back and forth on, and we have completely finalized, the substance of the terms, and we have an agreement in principle. So I do not imagine by the time we get the agreement to them, it will take very long to get it back.
Thank you. And I have another question, Assistant City Attorney. As we are getting acquainted with the procedure of this commission, if the majority of the commission wishes to do so, could the commission postpone this training?
This training is going forward as a work study or a staff presentation. It is not my understanding that this is an item upon which we could vote on and receive direction to postpone. That said, if the majority of this body were to seriously consider the postponement, that would necessitate a larger conversation for us to have. But my understanding is that at this moment in time, this is a staff presentation, and it would go forward accordingly.
So it's treated as a staff presentation? Mm-hmm. I see. And so I think I have received comments as well from residents prior to the commission with concerns about, bias, and this is no disrespect to you, Mr. Touchstone, but this commission was established at the brink of a lot of issues of mistrust with the police department that did not, spur out of nowhere. It spurred for years, about a decade or more. And so this is a matter of perception of this commission and the public's trust of this commission to act and make decisions in an unbiased manner. And so when we have, presentations that already become controversial and are divisive in the community as the matter of who's presenting a given, the background of who the presenter is, then that raises questions for me as to whether or not is worth the commission's credibility and public trust to move forward with this training. So I understand this is a staff presentation, but those are my comments. I think in addition, and I asked this question early on at an earlier meeting as to whether or not we could have alternative trainings to the commission by different other entities, and the response was yes. So I'm hoping that as the commission moves forward with the different trainings, that we look into what other alternatives could be. I know that we have Nicole and the other entities were presented, but those are my comments for this item and concerns with that.
Thank you. Any more questions from the other commissioners? Okay, we're going to move on with training now. Go ahead.
All right, fantastic. So can you pull my PowerPoint up, please? Folks, this is going to be a little bit of dense stuff. Like I said, I'm primarily focusing on the law. I'm also going to focus on the law as it's trained to law enforcement officers, because you're the folks who are ultimately going to be reviewing separate incidents. So my perspective is I think it's important for you to understand how law enforcement officers are trained throughout the state of California. So I'm going to be relying upon some materials put out by the California Peace Officer Standards and Training Organization. They are the commission which establishes statewide training standards for peace officers. They also update those standards on a regular basis. In addition, these are the standards which are applied to peace officers vis-a-vis civil litigation, vis-a-vis their actions. A lot of the policies that Santa Ana PD and all the 340 municipal police departments throughout the state of California look to these standards as far as implementation of policy, development of policy, training, and so forth. So we're going to be reviewing that. Again, this is just what the training says. I'm not going to try to push you in any direction. That is your role. That is not my role. My role is to simply kind of go over the law, tell you what it says, and if you have any questions about any of these slides during the course of this presentation, feel free to interrupt me. I'll try to answer those questions to the extent that I'm able. If not, I can get back to you. I'm happy also to provide you with a copy of my business card if you want to contact me offline and ask for clarification about anything that I say to you here tonight. You're more than welcome to do so. It has my email on it. I would ask that you email me individually It's not a matter before your consideration. Nevertheless, we want to be respectful of the Brown Act. I don't want to get any of you in trouble, and I certainly don't want to get in trouble myself. So, but I'm happy to do that if you'd like. All right? So, apologies to you at first, but I think that it's important to understand the constitutional underpinnings of a lot of the stuff that I'm going to talk about here tonight. So you're going to get a little bit of a refresher for basic civics that you probably received in high school and or in college and so forth. So obviously just kind of talking about the underpinnings here, I'm not going to read through these slides and kind of give you death by PowerPoint, but I thought it was important to, for you to kind of understand where I'm coming from on some of this stuff and ultimately how it affects you and your role as commissioners who are overseeing some of these issues. So obviously we started the Constitution of the United States of America. That is kind of the prime law for this country and is kind of establishes the premises upon which the California Constitution is based in large part, as well as the other states of the Union is what they have as well. So we have various amendments. They set up the legislative branches that you have here. You have obviously the legislative branch, of which you are a subdivision as a police commission oversight body, the executive branch, as well as the judicial branch. The folks that I deal with the most are the judicial branch. I also do trial work on behalf of various law enforcement agencies, and as noted previously, we also discipline police officers when they violate policies. Do, for example, internal affairs investigations for a variety of law enforcement departments up and down the state of California, and make recommendations as to whether or not an officer by his or her conduct may have violated the individual policies of those municipal police departments or sheriff's departments with whom we work. But if you kind of look at this, we have the Constitution. Obviously, we have the Bill of Rights, which contains the first 10 amendments to the Constitution. Some of those that you're probably going to be focusing on in your role as the Police Oversight Commission are the First Amendment, free speech rights, Fourth Amendment, certainly, and that's going to be the focus of kind of what I'm going to be talking about here tonight, which is search and seizure law, searches of homes, vehicles, persons, and obviously a seizure under the Fourth Amendment is the use of force by a law enforcement officer if he or she is acting within the scope of their course of employment. The Fifth Amendment, right not to incriminate yourself, right to remain silent, and also due process, as well as the Sixth Amendment, the assistance of legal counsel. We're going to hit more into the Fifth and the Sixth Amendment when we get into some discussions concerning POBAR and or if some other trainer is standing before you talking about that. I'm sure that you'll get it from them as well. Obviously, we also have the 14th Amendment. This is the Equal Protection and Due Process Clause. So those are some of the constitutional issues that you're going to be reviewing on a regular basis in your roles as commissioners on this commission. Again, this is, I'm going to skip that first thing. You can read it for yourself. The federal court system and the state court system, they are concurrent kind of oversight bodies when it comes to actions of law enforcement officers. There are 94 federal judicial districts. California has 4. We're currently sitting, the city of Santa Ana sits in the Central District. As you know, you have a federal courthouse right across the street over here. We also have the Northern, Eastern, and the Southern District. The Central District is probably one of the largest federal districts in the United States. There are also 12 courts of appeals. That is, we have above the district courts where your trials take place in federal court. You have the Court of Appeal. We sit in the Ninth Circuit Court of Appeal, along with the other states that I've listed on there. This is the largest appellate circuit in the United States. So when we get a decision by a federal district court, if one of the parties that has been in front of that court is unhappy with that decision, and when it's procedurally proper, they would appeal that decision to the Ninth Circuit Court of Appeals. That court would then have the opportunity to either affirm the lower court's decision or jury verdict, depending on what happened down below, or alternatively, they could overrule it. They could refer it back to the district court and said, you did something wrong. We don't like, for example, that jury instruction that you gave the jury. We don't think it's proper, so you need to retry the case, okay? You get one appeal to the Ninth Circuit Court of Appeals as a matter of right. If you're not happy with that decision, there are a couple of options, and this can be either plaintiffs, people who are suing police officers, or people who are defending police officers, the police officers themselves as the parties, or the city for that matter. Then they have the option of doing what's called seeking en-banc review, which is a large, so typically when you go to the Ninth Circuit on the first occasion, you have 3 appellate justices who are going to hear the case. If you seek on-bank review, that is not a matter of right. That is a matter of request. You petition for that. If the Ninth Circuit determines that there are enough justices who want to have that matter taken up on bank, then they typically appoint a panel of 11 appellate justices who will hear that case, and they will determine whether or not the three-judge panel got it right. And again, a variety of things could flow from that. They could say, yes, we affirm it, they made the correct decision. No, we think they make the wrong decision, here's why, and they'll send it back down to the district court for further decisions. So the reason I tell you all of this is to kind of just a basic procedural kind of lesson, if you will, on how this stuff can work. And it also kind of explains when you hear about an incident occurring in, say, 2015, why you don't get a final judgment or a jury verdict until, say, 2020 or 2022, because that case may have gone up and down that procedural appellate ladder a few times. So that can sometimes result in the delay before you get a final adjudication of the issues before. Alternatively, you can seek review if you don't like the Ninth Circuit three-judge panel before the Supreme Court of the United States. And again, that is a petition to have them hear it. Obviously, the Supreme Court does not hear that many cases. When you aggregate those 94 judicial districts and the 12 circuit courts of appeal, they take, I think, 0.001% of cases that they actually take up and review. And usually they look at an issue from the perspective of, does this have importance on a legal issue that's going to essentially affect the entire United States? Or alternatively, another aspect of a case that they look at is whether or not you have two or more of the circuit courts of appeal who have disagreed on an interpretation of law. So they'll take those cases up, the Supreme Court will, in order to get some finality on that issue. Because once the Supreme Court rules on it, it is the law of the land. So they interpret the Constitution, its scope, how statutory law should be interpreted by the lower courts and so forth. And once the Supreme Court rules on it, the issue is done, the legal issue is settled, unless you have a subsequent Supreme Court who decides that the prior Supreme Court got it wrong, in which case that is the supreme law of the land until that second Supreme Court decision overrules the prior Supreme Court decision before it on an issue, okay? Now, concurrently with that, we have the federal court system, obviously. We also have the California state court system. You have your California superior courts. You also have your courts of appeal, and in addition to the California Supreme Court. Ultimately, the same kind of decision-making pattern that I was talking to you about is concerning the federal courts. Now, the California Supreme Court is the final decision maker as to the scope of the California Constitution. The federal courts can rule on the federal Constitution, how that should be interpreted, but the California Supreme Court, in interpreting the California Constitution, can essentially make a divergent ruling that would be at odds in what is essentially very similar language if you look at both the federal Constitution and the California Constitution, as well as other state constitutions. For that matter, a lot of it they pull from the federal Constitution with perhaps some modifications. So if that makes sense to everybody. Same thing, you get one appeal as a matter of right to your district court of appeal, where the building is right next door. I've been in there a few times. And then after that, you have to petition for the California Supreme Court to accept your case if one of the parties is unhappy with the decision at the Court of Appeal, okay? And like I said, stop me if you have any questions about anything, but I did want to kind of get through that pretty quickly. Obviously, the Police Commission here was established in 2022 pursuant to Ordinance Number 3029. This sets forth your role. I'm sure you're all familiar with this. You know why you're here, what you're tasked with doing. I'm not going to review that. But you're essentially to act as an independent police oversight commission and have a separate layer of review on some of these incidents that may occur. I do think it's important for you to kind of understand the broader framework within which you sit, though, as far as different areas of oversight that are taking place with respect to peace officers and their actions here in the state of California. For example, you have the United States Department of Justice. They can bring charges for federal civil rights violations against peace officers if they believe that that peace officer has acted outside the scope of what he or she should have done under those particular circumstances. So we've probably seen some stories in the news where you see federal charges being brought up against peace officers. You also have the California Department of Justice, the California Attorney General, who also has the ability to bring state law charges for civil rights violations against a peace officer if he or she acted outside the scope of what was appropriate under the circumstances. In addition to that, you have the Post Commission, which I was speaking to you about a little bit earlier. The Post Commission is responsible for developing statewide training materials, some of which I'm going to discuss with you tonight, as well as under SB 2, the decertification bill. They can suspend a peace officer from having peace officer powers, or ultimately they can decertify a peace officer from having a peace officer powers. Finally, you have the Orange County District Attorney's Office. They can also bring state criminal charges for civil rights violations against a peace officer. And then you have the department itself, which has its Internal Affairs Division. They are looking at issues whenever a citizen's complaint is made to them. They are obligated under state law to investigate that complaint and make a determination as to whether or not that officer acted pursuant to policy based on his or her actions at the time. They can impose discipline. For example, they can suspend somebody without pay. They can demote a peace officer. They can also terminate a peace officer's employment with Santa Ana Police Department. Now, termination from the Santa Ana Police Department and decertification are two distinct things. Decertification, if done by post, results in that person not being able to be a peace officer in the state of California, period. So for example, if someone is terminated from Santa Ana PD, they could potentially find other employment as a peace officer within another agency in the state of California or in another state for that matter. However, if they are decertified as a peace officer, there's a national database for all decertified peace officers, and that is looked at. So for example, if you have an officer from Oklahoma who's decertified in Oklahoma and they come to apply for a position with a California law enforcement agency, then as part of the background check that goes along with that, that's one of the databases that is typically checked by, yes ma'am.
Yeah, I actually have a question on the decertification process. Can you briefly go over what accounts for that? Because I know that there's been in the news, right? I think we all have probably seen it, that an officer from Santa Ana PD has been caught drunk driving, so with a DUI. And I'm just wondering what the process for decertification is.
It's complex, and it was kind of outside the scope of what I was going to talk about today, but I'll give you a nutshell of it, if you will. And that was one of the things I was going to get into some detail later if you are kind enough to have me back, and if not, maybe someone else will get into it with you. But the way that that works is this. There are various areas of what are known as serious misconduct. There are 9 different categories. Here in California, if you are found to have violated one of those areas of serious misconduct, there's Government Code 1029, which obviously talks, if an officer is convicted of a felony, they can no longer be a peace officer in the state of California, okay? That's typical throughout the nation. We do not want convicted felons being law enforcement officers, clearly. There are also issues concerning dishonesty, use of excessive force, engaging in sexual assault or sexual misconduct, engaging in a pattern and practice of violating civil rights, false arrest, demonstrating bias in the casework that they do, and so forth. So once you have, typically a complaint will come into Santa Ana Police Department. Santa Ana Police Department will review that and determine if the allegation and the nature of the complaint meets one of those areas of serious misconduct. If it does, then the department is obligated to report that to Post. They then, Post then takes it and puts it in one of their databases, which they keep, okay? Santa Ana Police Department will then complete its internal affairs investigation and make a decision on whether or not that officer, in this case, violated Santa Ana PD policy and what the appropriate penalty, if any, should be. They may determine that the complaint is unfounded or not sustained. That being said, you have that independent layer of review. Again, you're looking at the nature of the allegation. So then Post can say, they send up a copy of their internal affairs investigation if it deals with any of those 9 areas of serious misconduct. They upload that to Post. Post then reviews it. Post may say, we think you, Santa Ana PD, need to do a better job in investigating this. We want you to interview this witness. We want you to consider this, that, and the other. Santa Ana PD is then obligated to take their internal affairs investigation, open it up, do the additional investigation, or alternatively, they have the option of saying, we think that we've done a complete and thorough investigation, in which case Post can independently investigate those additional areas that they want to receive more evidence in and so forth. They then ultimately package up the deal and determine whether or not it qualifies under one of those areas of serious misconduct. You also have a review board under SB2, which can independently receive complaints. So it doesn't have to go to Santa Ana PD. That review board, and I believe there's a state portal up right now, and correct me if I'm wrong, but I believe they've had it working now for a couple of years. So they will get a complaint. They will typically refer that complaint to Santa Ana PD to investigate, okay? And then that board makes recommendations. That ultimately goes up. They may say you should suspend, you should decertify, or essentially say we think it doesn't qualify as serious misconduct. Ultimately, if they're going to, it goes to the Post Commission, which is made up of a variety of community members throughout the state of California, very similar to the commission that you're on here today. And then they will make the final determination as to whether or not that officer should be decertified. So that's kind of the process in a nutshell, if that makes sense.
I have a follow-up question to exactly that scenario. I know that in our ordinance, it states that that we investigate complaints when it comes to on-duty police officers. In that scenario, it seems like he was off-duty, right? And he broke the law. Does that mean that the commission cannot be part of that investigation because the police officer did something off-duty? Is that something you can answer, or?
Yes, thank you, Chair Vega. I would need to, and I could even do it at this time, I would need to just further review the ordinance so that I could give you more clarity and a more definitive answer on that question, which I'd be happy to do. I'm not prepared to give you an answer right now at this moment.
Yes, ma'am.
Aren't you a police officer 24 hours a day?
You have peace officer authority 24 hours a day, yes. If a crime occurs in your presence, for example, when you're off duty, and it's your determination that it is appropriate to act immediately in order to prevent harm to a person and or property, then you have peace officer authority. And therefore, you can act as a peace officer. For example, I could be wearing a suit like this, or I could be walking around in sweatpants. If you're a sworn law enforcement officer and something is occurring in your presence, then you have the authority to act statewide in order to take law enforcement action. So you can actually arrest somebody even though you're not wearing the fine uniform that Santa Ana PD is wearing. I will also, to your comment, and I would have to review your commission, the scope of the commission's authority as well. I don't have that exact answer for you this evening. But what I will tell you is that peace officers are disciplined for off-duty conduct all the time. So you can be terminated for off-duty conduct. Doesn't matter whether you're actually wearing your badge and the gun at the time that the misconduct occurred. If you're violating departmental policy, you can be disciplined and or terminated. Okay? If that helps. Others, we got a little pause in the PowerPoint? Okay, fantastic. So those are kind of the various levels of oversight that we already have going on here, okay? Just to kind of let you know. A couple of things about lawsuits. Obviously, I saw that in your ordinance, you're going to get notice of tort claims as well as lawsuits that are filed against Santa Ana Police Department. So you're going to be reviewing some of that. So I thought it was pertinent to kind of briefly discuss some of that with you, how those lawsuits work, how they're filed, et cetera. So in addition to all the oversight that I just mentioned from those various bodies, wherein criminal charges can be filed against a law enforcement officer for his or her actions, there are also civil remedies that can be applied if a person feels that their civil rights have been violated. And there are various statutes which permit that. For example, I'm sure you've all heard of Section 1983, right? That is the enabling statute under federal law that allows an individual to sue for constitutional rights violations. That's 42 U.S.C. Section 1983. Before that enabling statute happened, there was not a private right of action for a constitutional violation, with very limited exceptions to that. So in other words, you can get your constitutional rights violated, but you couldn't go in and sue for a civil remedy. So this statute, which was enacted back in 1871, quite a bit ago, it had a little bit of a life of its own, and then through the 14th Amendment, it was ultimately interpreted to apply to the states. So prior to that, you just kind of had federal civil rights that someone could be sued, but there wasn't very much civil rights litigation under Section 1983 for a number of years until it was interpreted to apply to the states. After which now, I would say almost a majority of the lawsuits that are filed in federal court concern constitutional violations and the enabling statute, Section 1983. So we have that. You can sue for a federal constitutional violation either in the first instance in federal court, or you can sue in the California Superior Court, okay? So you have concurrent jurisdiction on those. Now, federal courts have what is known as exclusive jurisdiction over some types of federal claims, but the majority of them, like maritime law, admiralty law, things like that, Securities and Exchange Commission stuff can only be sued on in federal court, if I understand correctly. Certainly far outside my lane of expertise. But for purposes of why we're here to talk tonight, these Fourth Amendment violations, First Amendment violations, and so forth, those can all have a lawsuit filed in California Superior Court. Now, you have the option as a defendant, if it is filed in the California Superior Court, to remove it to federal court, because the federal courts, as I mentioned to you earlier, are the final arbiters on federal constitutional law. So you'll remove the case, take it out of Superior Court, the whole case is transferred over. The federal court then has various options when they get that case in front of them. If, for example, a motion for summary judgment is filed by one of the defendants in the case, and that results in the dismissal of the federal claim that gave the federal court jurisdiction to hear that case, then the federal courts say, I'm going to go ahead and keep, because it's in front of me and I know the case, I can keep the state law causes of action, which may have also been filed with the federal causes of action. So, for example, what you will typically see if a plaintiff files a lawsuit concerning civil rights violations is they'll assert whatever the amendment is that they believe their civil right has been violated, right to free speech under the First Amendment, an improper use of force under the Fourth Amendment. They will also file in that same complaint for damages where they're seeking money. Okay, they can also seek injunctive relief. You shall not do this any longer, or you shall do this from here on out. Okay, so you have monetary relief or injunctive relief that can be sought in either one of these types of lawsuits. The federal court, if it no longer has any federal claims in front of it, can keep the case, like I said, or they can remand it. They can do what is decline to exercise supplemental jurisdiction. Because the only way they can hear those state law claims is if they have a federal claim on top of it. Otherwise, the federal court does not have jurisdiction to hear state law claims unless there's a basis for jurisdiction otherwise. And one thing you may have heard of is diversity jurisdiction. You have to have a claim over a certain amount, and you have to have a plaintiff and defendant that are living in different states and so forth. So you can have diversity jurisdiction, which would permit violations of state law or allegations of violations of state law to be adjudicated in federal court. That being said, primarily what I deal with on the work that I do, in my day job, so to speak, and what you're going to be dealing with are going to be those federal claims, and they will overlap. So, for example, if you have use of excessive force under the Fourth Amendment being alleged, you will typically have a state claim for battery. Because if a peace officer goes outside the scope of what is objectively reasonable, then they violated that person's civil rights with respect to their use of force, and they have also battered that person. However, the typical battery, and you hear people kind of confuse assault and battery all the time, or they say it as a concurrent thing. They're actually two distinct things. Assault is saying, I'm going to hit you in the head with a baseball bat, and I have the present ability and the apparent intent to do so. I've threatened you with the use of force. That's assault. Battery is if I actually strike you with that baseball bat, okay? So, but you will usually get claims that are kind of going on both those pathways. Fourth Amendment violation, state law battery. You may also get negligence. So while a use of force may not be a constitutional violation and it may not be a battery, an officer may have still been negligent in the use of that force. They violated some standards. And that's, for example, where sometimes you will see portions of a police department's policies get brought into evidence before the jury so they can say, here's what the policy says, and this is what they did. So you tell me, were they negligent? Did they act in a manner such that we expect our police officers to act in any given circumstance, okay? So you can also be found negligent, even though it may not be a direct volitional constitutional violation. So, what else was I gonna say? State court can also hear federal claims as well, and they can adjudicate a Fourth Amendment claim in addition to the federal courts, okay? Yes, ma'am.
I have a question. I would like clarity on the example you just mentioned about assault and battery and whether an officer threatens or actually acts. So if it's just a threat, right, how do you decipher whether it's something that somebody can claim is assertiveness or asserting their power versus like an actual threat? Like, is there, it seems like to me a little bit gray, right? For example, a police officer who feels unsafe and might assert power to create safety, right? Safety for themselves. And put safety because that can be, subjective on how people feel safe in certain environments. But how do you decipher a threat versus someone claiming to be assertive? Like, because that to me is a threat anyways. Like if somebody is threatening someone to hurt them, right? Can they claim that they were just asserting safety?
Well, yes, is the short answer. It is a world of gray, as you mentioned, which is why I'm focusing on just the black letter type law. There are nuances in the application and arguments. And so, for example, a peace officer is entitled to utilize force to do their job. They are also entitled to tell you, do this or I will use force, which if I said that to you, I'm not a peace officer, that would be potentially an assault. Do this or I'm going to tase you, for example, or I'm going to pepper spray you. Stop or I will shoot you. Use of deadly force, okay? So that would all potentially be deemed a threat from someone who does not have peace officer powers. However, a peace officer is authorized pursuant to law to utilize force under certain circumstances. They are also required to usually tell somebody that they're going to use force against them if they have the opportunity and it's feasible and it won't increase their own safety, and also consistent with principles of de-escalation. So for example, if I've asked you to turn around 10 times, put your hands behind your back, you're under arrest for X crime, and you refuse to do so, then, we're gonna hit this in some of the slides later, what California law says on this issue, then an officer is entitled to use force to effectuate that arrest. So if you refuse to comply with my request, commands, threats, however you want to characterize it, then the officer is entitled to utilize force to effect that arrest and make it, okay? So they have the ability to use force to put handcuffs on you, take you down, book you on whatever criminal charge they're there for, and so forth. So some of that same conduct by me, then he would be putting handcuffs on me if I said it to you, for example.
Got it. Maybe I misunderstood. I thought this component was for peace officers. Like it applies to peace officers and everyone? Like what you're discussing right now on slide page 4. So section 1933 that you mentioned.
1983.
1983.
Uh-huh.
This applies to?
So section 1983 is the enabling statute that allows you to sue for constitutional violations. So you're reviewing peace officers' conduct. If a peace officer is not acting as a peace officer at a time, they're not exercising peace officer authority, then they are a regular citizen. So while they may violate your constitutional rights, it's not what's known as under color of law. Okay, so that is one of the requirements for section 1983. if that makes sense. They may still be violating state law. For example, like I said, if I threaten you. Let's assume you have a cop who's out at a bar, and he or she is not being a peace officer at the time. They're out having a beer, watching a football game, whatever the case may be. And they start threatening an individual, and then ultimately they get in a fight with that individual. So you have a variety of paths that would take as far as where the,
Makes sense now, thank you.
that makes sense? Okay. So, and that, first off, they're probably going to get disciplined, potentially fired for engaging in that kind of conduct, criminally prosecuted by one of those agencies that I talked to you about previously. Whether or not they're acting as a police officer at the time, you're still responsible for your actions, okay? If that makes sense and clarifies it a little bit for you. Okay. And if not, let me know and I'll try to do a better job. So, you preceded my next slide here. Police officers acting under color of law. This is what it takes to be sued under Section 1983. Otherwise, like I said, you're just kind of looking at another state claim, say for battery or assault or whatever the case may be. But you have to have an officer acting under color of law in order to be sued under Section 1983. So, and what does that mean, under color of law? So here are some factors that courts look at when they're making a determination as to whether or not a peace officer is acting under color of law. Number one, a clear indication, was that person on duty? Number two, were they wearing their police uniform? Number three, were they using police department equipment, squad car, service weapon, handcuffs, taser that is issued to them by the department? Actions consistent with acting like a peace officer. So for example, a police officer is still in uniform, however they've clocked out for the day, so to speak. They are driving home in their own personal vehicle. They're still in their uniform. They didn't change for whatever reason. And they've got their equipment belt on, or Sam Brown, as it's commonly known, the belt that holds all the stuff that police officers use. They're getting gas at a gas station, and they see somebody start to rob that gas station. And then they start acting like a peace officer at that time. Hey, stop. They try to prevent the robbery, or they try to take that person into custody. In that case, they're acting under color of law. Now, let me change that scenario for you a little bit. Let's assume that they are in sweat gear. They're off duty, put on their sweat gear, same scenario, going to get gas. However, they still have their service weapon with them, and they're pumping gas. They see that robbery. They do the same thing. They act as a police officer. They say, stop, I'm a Santa Ana police officer. Stop, put your hands up, get down on the ground. Okay, even though they're quote unquote clocked out, they have that peace officer authority that I was talking with you about earlier, and they are exercising that at the time. They're not just defending themselves, they are actually trying to enforce the law and take somebody into custody, which is what they get paid to do by the city of Santa Ana. Then, even though they're off duty, not getting paid at the time, they are likely to be deemed acting under color of law, if that makes sense. Yes, sir.
So if there's a police officer at a bar, let's say, and they're in plain clothes, and they get in a fight with somebody, they punch them, they injure them, and that person brings a tort claim, could they sue them could they bring a 1983 claim against them, against the police officer?
I would need some more facts. So for example, if in that fight they pulled out their badge, flashed it, and said, you need to stop, don't touch me, I'm a police officer, and if you touch me, I'm going to arrest you, and then the fight ensues after that, the answer is arguably yes. Potentially no as well. But it's that exercise of the color of authority, essentially the exercise of their peace officer powers, which triggers that under color of law provision. So for example, there's a case out of Hawaii where you had an individual, he was I think he worked for the Honolulu Police Department. He was hired to provide security for a New Year's Eve party, and somebody became intoxicated in that party, didn't have a ticket, wanted to get in. Ultimately, use of force occurred. Now, the Honolulu Police Department had a law a policy provision that said no outside employment, can't do it. He was wearing a security guard uniform, not Honolulu PD uniform. And nevertheless, he was deemed to be acting in the course and scope and therefore under color of law. However, the court also said that he was not entitled to the defense of qualified immunity, which is a federal defense that we'll talk about a little bit tonight. So I call that the most difficult of all worlds decision, because now you can be sued under federal law, but you don't get the benefit of federal defense. So it's kind of a situation that can, that's why I say it depends. You'll hear that a lot from attorneys, it depends, because frankly, there's my opinion, there's someone else's opinion, and then there's the court's opinion on what the law actually is. And the people wearing the black robes are the ones who ultimately decide that issue, not me. Esquires like myself, we're paid to represent clients and make arguments. Ultimately, some of those arguments fail. I just have to have a colorable, good faith belief that I can make a credible legal argument to make the argument. And whatever the jury or the court decides is ultimately where it comes down. Okay?
A
Yes, sir.
quick question for you. In the scenario where the officer's off duty, in his sweats, goes to the gas station, gets gas, and fails to act, any consequences for that?
No liability consequences. No. Now, there may be some policy implications. So depending on what the policy says, like if you see a crime in action, you're required to act and exercise. Usually officers are given discretion. That's kind of a department by department type situation. But there is no civil liability. You cannot get sued for failure to act except in very limited circumstances, which is, you think this is boring. If I start getting into that one, you're really going to fall asleep on me, okay? But essentially, you have to assume what's called a special relationship with somebody. We're the police, we're going to protect you, and then you don't protect them from a third party's harm, then you could potentially be sued for that. Otherwise, there's no legal duty to act, okay? Yes, sir. And then, obviously, going down to the list here again, whether or not someone actually effected an arrest. So a peace officer may even defend themselves. So let's say they get attacked, someone's trying to rob them, they're a police officer, but don't have their badge, don't try to arrest someone, they end up discharging the department-issued gun at that person who's trying to attack them. They may not be deemed acting under color of law, and likely would not unless some other factors were present. So it's really a case-by-case determination, and you really have to kind of get down in the weeds and look at some of the nuances on how that stuff plays out. Okay? So now we talked about Section 1983, that federal enabling statute that permits people to sue for civil rights violations. There's also some provisions of state law which might come across your desk. You'll see some of these alleged in some of the complaints that you get provided as well. The Ralph Civil Rights Act, this comes from Civil Code Section 51.7. This is essentially to prevent discriminatory action against somebody based on their race, a variety of other factors that come into play, if they're participating in a labor dispute. Generally speaking, this enables constitutional violations that occurred because of somebody's protected status, whatever that may be. Sexual orientation, race, age, whatever the case may be. There's a variety of things. Then you have the Bain Act, 52.1. This is if you have a law enforcement officer who is acting in the course and scope of their duties as a peace officer, and they violate somebody's constitutional right, and in fact, this says whether or not acting under color of law, if they interfere by threat, intimidation, coercion, attempts to interfere by threat, intimidation, and coercion with the exercise or enjoyment by any individual, impairing any of those rights we talked about, either under the federal Constitution, laws of the United States, California Constitution, California laws, they can be held liable under the Bain Act. So that's kind of the state law equivalent, if you will. Bain Act is kind of interpreted a little bit more narrowly than a Section 1983 action. It requires certain other factors and evidence to be presented on it, but it's very similar in effect. It's just the state law equivalent. Focusing now on the topic of use of force. Kind of the seminal case that we talk about when it comes to use of force is a United States Supreme Court decision called Graham versus Connor. This was handed down in 1989, and this established the current federal standard for judging a peace officer's use of force, and that standard is objective reasonableness. So what does that mean? It can be a little bit confusing. You have subjective beliefs, and you have objective reasonableness. So subjective, obviously, is what you have in your head and your heart. Objective is what society is prepared to accept as reasonable under the circumstances. So really, when it comes to federal law, it doesn't necessarily matter what the officer's thought process was as far as whether or not he or she intended to violate civil rights. From a liability perspective, they can say, I absolutely had no desire at all to violate somebody's civil rights. But they can still be held liable under Section 1983, even though if they had the best of hearts. They're still judged the same. Conversely, they may have had a subjective belief that was never expressed other than in their own head of, I'm going to violate this person's civil rights, I'm going to do the wrong thing here, but they may still not be liable under Section 1983 if their actions are objectively reasonable. So best of hearts, worst of hearts, they still have to satisfy these same standards of objective reasonableness. Well, let's talk about what that means if I don't trip and fall and break my neck. So when you look at this, what this court decision says is you have to look at these various situations based on what is known as the totality of the circumstances, okay? So a variety of factors can come into play. And the court also said that the determination of reasonableness must allow for the fact that peace officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. And this is Supreme Court words, not mine, just in case you were wondering. I probably should have threw some quotes around there. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. The evaluation should be based on the facts and circumstances confronting the officer without regard to the officer's underlying intent or motivation. That was kind of what I was talking about as far as the meaning of objective reasonableness, okay? So here's the case, and this is an interpretation again. This is not my spin, folks. I put the case citation there. Feel free to look up the case, review it. That's why I throw the citations in there. So this is not Jim Touchstone talking, other than I'm the one standing in front of the microphone in front of you. I put quotes around it if it's in the legal opinion that I'm reading to you. Now, this case, which was just recently handed down towards the end of 2023, it is a Ninth Circuit case, which, as I told you, is a case law which governs us here in the state of California with respect to federal law, unless there's a differing opinion from the Supreme Court. Ninth Circuit is the law of the land as far as California is concerned. This is a case called Estate of Strickland versus Nevada County. And in this particular instance, and again, this is in quotes, when someone points a gun at a law enforcement officer, the Constitution undoubtedly entitles the officer to respond with deadly force. Another case citation to a prior Ninth Circuit opinion. But what if the person points a replica gun that the officers believe is real? In this case, we must examine whether it was objectively reasonable for officers to believe a black toy airsoft rifle pointed in their direction presented an immediate threat justifying the use of deadly force. Based on the facts here, we say yes. So in other words, the court is finding that these law enforcement officers did not violate this individual's constitutional rights when they shot and killed him because he pointed a replica gun at the officers at the time that they believed was real, okay? And again, this is from the case. A man was walking on a residential road with what appeared to be a shotgun slung over his shoulder. The man told the officers that the gun was a BB gun. The officers didn't know if the gun was real or not. This individual was actually known to be mentally ill by these particular deputies who responded. They told him to put the gun down multiple times. He did not do so. He kept it pointed at the at the ground for a long period of time. However, the officers, several deputies shot this individual when he brought that quote unquote gun up and started pointing it at the officers. And they said, we didn't know if it was real or not. Turns out, in 20/20 hindsight, that was not a real gun. It was a replica gun. Nevertheless, when judging them under Section 1983 and the objective reasonableness standard, the court determined that they did not violate his civil rights, even though looking retrospectively back at it, that was just a replica gun, which would not clearly justify the use of deadly force in that circumstance. Now, I'll tell you a couple of things. This is a tragic situation, no doubt. You have somebody who's suffering from mental illness, was in a mental crisis at the time that this incident went down, and that person lost their life, and that is tragic. There are, however, situations that I'm aware of. There's some training that takes place. There are examples that can be pointed to. For example, there are some bad people who violate the law consistently, who have taken a real gun and have painted the tip of it orange so that it looks like a replica gun. Law enforcement officers do receive training on that because it has happened on multiple occasions. And these are bad people who are looking to get that one extra second of hesitation by an officer who says, is that a replica, is it not? And they shoot the officer, kill the officer, because that officer hesitated when looking at that orange tip, not knowing whether or not that was a real gun. There are also instances where, have you ever heard of a super soaker? I don't know if any of you have kids. Those big squirt guns, where those have been taken and hollowed out, and a shotgun has been placed up inside the super soaker. So, like I said, these are bad people who are looking for ways to harm people, get the jump on law enforcement officers, and so forth. That is why we're not to judge these situations from 20/20 hindsight. It is an entirely different matter when you're out on the streets dealing with these folks, other than when you're sitting in a federal court and you have to take off your shoes, your belt, pull out your wallet, show your ID, run through a metal detector, have everything that you bring into the courtroom scanned to make sure you're not bringing a weapon in. Very different matter, dealing with someone 2 a.m. in the morning in an area that's known for a significant amount of violent crime, and you have one of these things that might be pointed at you. It's dark, you can't see necessarily, and even if you can see it, you don't know if it's real or not, if it looks like a gun. Sometimes there are tragic situations that occur. Look, loss of life is tragic, period. Whether or not the use of force was, deadly force was justified or not. Somebody is still perhaps seriously injured and or dead, whether that is a suspect or if it's a peace officer. It's terrible. That is why officers should typically are providing options to a person to de-escalate the situation. In fact, they're obligated under state law to de-escalate a situation. That's why if you're going to see some body-worn camera footage from some police encounters by Santa Ana PD, if they have the opportunity to do so and it's not going to increase the risk of threat to their safety, they're obligated under state law to de-escalate a situation or attempt to. Now, we all hear about de-escalation, and I will tell you, it's one of those words.
Excuse me, Commissioner Pereira, you had a question, right?
Oh, I'm sorry, sir. I didn't say
Sorry,
that.
I'm curious as to, with the specific case in Nevada County, if the case took into account, or the case, or the courts look into what leads to the incident. So we're talking here about the fact, right, that the deadly use of force was used. But the courts take into account what led to the cop's decision to use that use of force. So, for example, it seems that right there in that case, local police was aware of this individual being mentally ill. Were questions being raised during that case about different approaches to this individual? I imagine maybe the contact with police led to like the individual being more alarmed and more aggressive. What were those things considered in this type of cases?
Yeah, everything was considered. So for example, this was a call for service. It was a person who lived in this particular jurisdiction, saw somebody walking down the street with what appeared to be a shotgun. So this was not a law enforcement officer who was just driving by and saw this person. It was someone in this community who saw this happen and was very concerned. Oh my goodness, there's someone walking down the street with what looks like a gun. And then the deputies, some of whom who knew this person through their prior interactions with him and knew he had mental illness, attempted to de-escalate the situation. They spoke with him for several minutes during this encounter. They didn't just walk up and shoot him, in other words. When he had what appeared to them to be a viable gun pointed down at the ground, no force was used against him. They were trying to talk to him, put the gun down, let's talk. I think they even knew his name, for example. They were calling him by his first name. Unfortunately, he didn't listen in that situation due to mental illness or what. You and I will never know. It could have been mental illness. Many times when a law enforcement officer encounters someone and the officer gives them a command, they may just simply not obey. So there are various reasons why that may have occurred. And then ultimately, when he started bringing that weapon up and pointing it at the officers, those deputies had to make a decision. Are they going to shoot or not shoot? And that's when it happened. But yeah, like I said, I put the case citation in there. The case opinion itself, I think, is like 15 pages long or something like that, obviously beyond the scope of what we were going to talk about here tonight. But I encourage you, you can Google the case, look at it, read the entire opinion. It'll fill in more details than I've discussed with you here tonight. Okay?
So de-escalation changes a little bit when it is known that you're dealing with somebody with mental illness. Do you kind of just give them a little bit more time, or?
You can certainly try to, yeah, and officers are trained to do that. If they know someone is mentally ill, then they receive training. It's called Learning Domain 37. I'm not going to discuss it here with you tonight, but it discusses a variety of things as far as attempts to de-escalate a situation. So, for example, in my experience, if you have an officer who has encountered someone with mental illness, if it's on their regular beat, then they may know that person. They may know that he or she suffers from mental illness. A lot of times they will try to develop a rapport. Many times, unfortunately, these folks are homeless as well. And so they're seen by the same law enforcement officers who are operating in that same area. And usually they have some interactions with them, develop some kind of a relationship with them, maybe offer services that the city may offer, for example, assistance services, and so forth. And when they encounter those individuals, they know they have a mental illness, to be distinguished from someone who may be drunk or who may be high on drugs. And that's where the rubber kind of hits the road a lot of times, folks, is some of the symptomology that is displayed by people who are taking certain types of drugs is very similar to someone who is experiencing a mental crisis due to a mental illness. Those can be difficult to separate sometimes. They're law enforcement officers. And I want to put it in a little bit of context for you. And this is, so for your consideration, let's say that you have a psychiatrist who has gone through thousands of hours of training as a mental health care professional. And those people are in a hospital setting. And that hospital may be one which deals with a certain clientele who come in, or they may be one of the locations where people take 5150 detainees, someone who's been taken into temporary police custody to have their mental status evaluated as to whether they're a danger to themselves or others. So let's assume it's a psychiatrist on staff at a major hospital with all these thousands of hours of training, medical school, et cetera. They also have a clinical practice where they are meeting with thousands of patients over the course of their 20-year career. They're issuing antipsychotic medications, things of that sort to somebody. So when we talk about officers who are encountering people with mental illness in the streets, and they may have other issues at the same time. So, for example, if someone has a mental illness, they may also be on drugs. They may also be drinking at the time, which may affect their behavior. So there's kind of that cofactor of things that could be happening with respect to that individual. But going back to my psychiatrist example, someone who has top-level training in dealing with folks who are suffering from mental crises. They come into the hospital, they get brought into the hospital under 5150 detention. And that person, while in the hospital, picks up a scalpel and starts going at the psychiatrist with all that training in mental health care. So one might ask, why didn't that psychiatrist with all that training, all that clinical experience, why didn't he or she just simply de-escalate the situation? They've got all that training, right? The issue is de-escalation takes two. It is a dance. You can attempt to de-escalate all you want. So a common de-escalation thing, sir, put the scalpel down. Put the scalpel down or I'm going to call people with guns and badges. Right? That's what many times happens. So the reason I tell you that story is, number one, it's real. If you don't believe me, that's fine. Call a psychiatrist friend you have who works in a trauma center in a downtown urban environment. Ask them if they've ever called law enforcement in to assist them when they were getting physically attacked by someone who was brought into them for treatment. Pretty sure I know what the answer is, but again, investigate yourselves. Don't take my word for it. Yes, sir.
On that topic, I mean, we're talking about use of force, right? And
Yes,
when,
sir.
when it's appropriate and when it's not appropriate. I'm also wondering, and perhaps we might get this into other future trainings in terms of when use of force is used, what are the procedures for that? I mean, police officers carry
Oh, we're going to chat about that tonight.
stun guns. I'm guessing also there is procedure around where to shoot, how to disable an individual. So I'm curious as to, on all these national headlines that we have around police, custody deaths, a lot of things come to mind about what's the training that goes in place and what are the things that officers have to take consideration into how police use of force is used, the types of police force that are used, whether it's a stun gun, a gun, whether it's shooting the head, shooting the chest, shooting the arms, all those
Right.
things. I think those are things that are going to be very important for this commission as we go, go
I agree
into
with you
this.
100%. And you've got a long lead up to me getting into that. We're going to chat about that tonight. And the way that I want to do it, because you are, yes, sir.
Real quick on that point, I mean, there's typically a ladder of force, correct? I mean, the verbal commands and then you escalate up. Your first call isn't going to the firearm. It's going to be something less lethal, correct? Typically, that's how, am I correct in understanding that?
Well, you're, sometimes. It depends. Let's put it this way,
No,
sir.
I appreciate that. I
Yeah.
appreciate it's situational, but again, your first call of action is not going to be to go for the firearm.
No, absolutely not.
So
Nonetheless,
you're going to try, if they don't cooperate, then you have to, if they don't respond to verbal commands, then you have to escalate up. They don't respond after that, then you escalate it up. I mean, it is a ladder of force, correct?
yes, sir, that's a typical progression.
Yeah,
It's situationally dependent, of course.
Situationally dependent. Your last line of resort would be the firearm.
Correct.
Deadly force.
That is correct.
Thank you.
Yes, sir. Yes, ma'am.
Yeah, I just wanted to highlight that this example that you just described about the psychiatrist is exactly what I find problematic from a legality perspective, because of course, someone who has substance use disorder or someone who has mental health, mental health is quite common. I'm sure you have a family member and can relate to someone being on some type of thing. And so, of course, if somebody is receiving verbal command and they are either in psychosis or having a mental breakdown or under the influence, they're not going to respond because they're not in the right mindset to respond, right?
Potentially not.
And then that gives legality and justification to the escalation of how the things are used and justified legally, even though unjustly. And this is exactly what I find problematic, right? Because you're making the argument, despite the fact that you said that we have the ability to make our own judgment, you're providing legality to back up why this justification of an action of a police officer is able to do and justify it, because legally they are, right? They did the command. There's limited actions that they can do, which is the problem, is a societal problem, right? That not law enforcement can solve all these issues. And I'm sure some law enforcement can say, yes, we're not mental health experts. But then by providing this exact example, you are again showing how the justification of such use of force can actually be justified. And I just wanted to highlight that that is exactly why I had hesitations at the beginning. And I would appreciate if further examples are better aligned in the legality of things rather than this, because it is problematic.
Okay. I'm not exactly sure how to respond to that.
I think what you're talking about is a threat is a threat.
Absolutely.
Violence is violence,
Sure.
regardless of what mental state you're in.
Sure. Officers are reacting to actions. They're not acting, just like they're not judged by motivations, they're not judging a person who they're encountering by their motivations. If someone is suffering from a mental illness and they're pointing a gun at you and shooting you, you're still seriously injured and or dead. If they're completely and totally sane and acting out of criminal animus, they point a gun at you and they shoot you, you're still seriously injured and or dead. So what's going on in here is not what an officer is reacting to. They're reacting to the physical actions that they have to deal with under the circumstances. So that, and the mindset may be an enhancement, or it may be from a criminal perspective, or it may be, for example, premeditated murder, Or it may be a situation where someone is not criminal, or they receive a lesser sentence due to their mental state. Or they're not guilty at all of any criminal behavior because they didn't have the capacity to make a decision. But regardless of what that situation is, the law enforcement officer is responding to actions, okay? Yes, ma'am.
Well, back to the scalpel again, the case of the scalpel. Whose fault is that to begin with? Think about it. Psychiatrist's fault. If he knew he was dealing with somebody that had mental problems, those scalpels should not have been out.
True.
For this person to have grabbed them. They should have been locked up and put away.
True.
So it's the psychiatrist that caused the problem by not thinking.
Certainly, there's some culpability there from my perspective as well. Agreed. Those are real-world examples I'm giving you. I didn't just make that up, by the way.
Excuse me just a moment. That's where we, as a group here, are going to have to stop and think and, weigh both sides, just like that one right there, okay, that I gave the example. If that came before us, okay, I would say, I would not blame, was it the officers or so, or the man who was mentally ill? I'd go right to the psychiatrist. He caused it to happen through his carelessness and not thinking.
Yeah.
So that would be kind of a hard decision to decide whose fault really was it in that case.
No, agreed. There are nuances and various, there's a lot of room for judgment here, folks. I can't give you a quote-unquote right answer. Everything is obviously subject to what you bring to the table with your life's experience, maybe what I tell you, maybe what someone else tells you from this dais some other night. And, that's your role. I'm not here to usurp your role. I'm just here to kind of give you what the law says and some examples of how I've seen it applied, some situations that I've become aware of through my 28 years of working in this field. And there may be somebody else who's in front of you who gives you a very different perspective and different life experiences that they've come across. And I respect that. We can agree to disagree on things. I'm not here to agree or disagree with you. I'm just here to chat with you tonight and try to answer your questions. So.
I was just using that as an example.
Yes, ma'am.
I certainly wasn't.
No, I
getting it
appreciate
at all.
that. I appreciate that.
I had my finger, and I had to get that out real quick.
I apologize for the interruption. Chair Vega, we've been speaking now for about an hour and a half. I'm wondering if this body would consider taking a maybe 10-minute break.
I think it'd be a great idea. Sometimes I just get excited, so I don't recognize what the timing is, but.
Agreed. So let's go ahead and take a break, and we'll come back and continue the training. So I'm going to recess this meeting, and let's take 10 minutes. So let's get back at 6:36 p.m.
Sounds good. Thank you. Test.
Madam Recording Secretary, can we continue the meeting?
Yes, Chair Vega.
Okay, we are back from recess and we are resuming this meeting. The time is 6:39 PM and we are continuing with item 2 of the agenda.
Thank you, sir. So before the break that we took, we were talking about kind of use of force and federal law and that issue, which is fairly concurrent with state law. I also want to talk to you about post-learning domain 20. And the reason I'm doing that, folks, is this is the learning domain that is utilized in police academies throughout the state of California as far as training on the use of force. This is how law enforcement officers are trained, in addition to the training that they get while at the department, going through a field training program, becoming familiar with their department's policies, procedures, specialized training that may vary from law enforcement agency to law enforcement agency throughout the state, and certainly with respect to the issue of certain different kinds of force options where they have to go through additional training. For example, before they're permitted to use a taser in the field, before they're permitted to use a 40 millimeter less lethal launcher, OC spray, for example, all of that stuff, okay? So this is the law on the issue, and this comes again from Graham versus Connor, that Supreme Court decision that I mentioned to you. And these are the factors that go into consideration. And if you go into federal court tomorrow, if you're selected as a federal juror and it's a use of force case, these factors are going to be read to you because they're inculcated into the Ninth Circuit's jury instructions that are read to you when you're judging someone under a federal use of force case, okay? So the first factor is whether or not the suspect posed an immediate threat to the safety of the officer or others. You also look at the severity of the crime at issue. You look at whether the suspect was actively resisting arrest, whether the suspect was attempting to evade arrest by flight, and then you also take into account, again, that split-second judgments during circumstances that are tense, uncertain, and rapidly evolving. And of these factors, the most important one is whether the individual poses an immediate threat to the officer or the public, okay, as far as judging use of force after the fact. Also, there's some other factors too. Those are the kind of the main ones that the courts focus on when making decisions on this. And like I said, you're instructed on that. But there are other factors too which come into play. I used earlier that phrase, totality of the circumstances. And essentially, you're looking at the big picture of what the officer was facing, what the officer was doing, what the person who they're encountering, what they were doing. Environmental factors, night, day, rain, sunshine, whether or not that person is known to the officer. For example, whether or not that person may be associated with a criminal gang, things of that sort. All of that comes into play, or what they're told. And sometimes officers are told things which are not true. They are given false information, either intentionally or just by a mistake by a person. But nevertheless, they operate on that. They try to investigate if time permits and gather the true facts and circumstances and find out what they have before them before they act, if time permits. All of this is situationally dependent. You, sir, asked a cogent question earlier about typically you try to go up that use of force ladder. The answer is absolutely yes. Hopefully, there's never a use of force at all that occurs. Hopefully, we can simply resolve the situation. There may not be even be a crime, folks. When a cop comes in and encounters someone on the street, what may be from appearances to be consistent with criminal behavior may ultimately be completely innocent. Have a good day. Thanks for talking with me. Alternatively, it may be a criminal action that's being taken by the person. So it really just depends on a variety of these things. But here are some of the other factors that federal law and state law, for that matter, instruct you to kind of consider when you as a commissioner are going to be making a judgment. Because essentially, I look at you as a jury. You're essentially judging an officer's actions after the fact. You're operating as a jury as far as this is how we see it, and these are recommendations that we're going to make we think would be appropriate to make policing better in Santa Ana. That's what it's all about, right? Everyone wants to get better, whether it be the cops, whether it be the citizens who want better cops. Everybody, typically, if they're doing things the right way, everyone wants to raise the water level. The ship gets higher for everybody. We have less uses of force. We have less criminal activity. We have less false arrests or allegations of false arrests, et cetera. So everyone, we want to make everybody happier if at all possible. So these factors, when you look at that, whether there's an opportunity to warn about the use of force prior to it being used, and if so, whether that warning was given. So people say, well, why didn't you tell them you were going to shoot? Well, sometimes you don't have an opportunity. Sometimes you do. Sometimes they don't think of it. Let's not forget that cops are humans too, despite all of the training that they go through. And there are certain physiological effects, like we talked about mental illness earlier. There are certain physiological effects that people who are under high stress situations, it happens to them and they can't control it, their body's reaction. So for example, let me give you a real world example that has nothing to do with law enforcement. Have any of you ever jumped when someone snuck up behind you and clapped your hands? Right? Have any of you ever froze? You got so frightened, you do one of those kind of things. I know I have. I got surprised, something happened, and my body involuntarily reacted to it. So sometimes when, and this is, like I said, it's a traumatic event. It's something that's stressful. Near miss in a car, something that we can all relate to. Sometimes your body reacts. Afterwards, your hands start shaking, you start breathing, oh my goodness, I almost got killed there, or whatever the case may be. You supply your own example based on your life experiences. But there are physical actions that kind of take place there sometimes that are, despite all the training that we have, sometimes an officer, due to physical limitations, cannot necessarily apply that training in a manner that maybe should be expected of them. Maybe they could have done it better. No doubt about it. We all strive to be better. But so you look at that warning, if feasible, if I'm 10 feet away from you and you don't have a gun in your hand and I'm encountering you and we're getting to the point where I'm about to use force as a peace officer against you, then absolutely I should try to warn you. Because that's also consistent with principles of de-escalation. Because if I tell you, I take the taser out of my holster and say, sir, I've asked you 5 times to turn around and put your hands behind your back. You are under arrest. You're not free to leave. I'm going to place handcuffs on you. And you're refusing to do so, then I pull out the taser and say, sir, I'm going to tase you. I don't want to do that. You're going to put me in that position where I'm going to tase you to take you into custody. It's going to hurt you, this, that, and the other. Sometimes people comply. I will tell you, if I ever hear anyone say, hey, put your hands in the air, we're going to release the police dog, my hands are going up, okay? My hands are going up. So these are all things to kind of consider in this situation. So was it feasible? Is it going to increase the risk of danger to the officer if they give the warning, then they're excused from that sometimes, or if they don't have time or this, that, and the other. Those are some of the factors. But generally speaking, if they have time, it's not going to increase the risk of their safety. Absolutely should be giving warnings before this, any kind of use of force occurs. Again, whether there was an assessment by the officers of the suspect's ability to cease resistance or comply with the officer's commands. So the example we were talking about earlier, mental illness, that can obviously, if somebody is cognitively impaired, they may not understand what the officer is saying to them at the time. They might as well be speaking Egyptian. Or there might be a giant bug that that person is seeing talking to them. You never know. There are a variety of situations that may occur. And an officer, if they perceive that, they should certainly take that into account and how they're dealing with that individual. So I was talking to you about that beat cop earlier. There may be somebody else on that beat who has a very good relationship with someone who has mental illness. And while they may not be responding to this officer, Susan, I need you over here on the corner of 5th and Main. Tommy's here. You know Tommy? Yeah, I know Tommy. Susan shows up, Officer Susan. And Susan knows that Tommy loves a certain football team or whatever. Start talking about the Chicago Bears, Tommy calms down. No force needed to be used. Sometimes if you have that luxury of that time and that opportunity, it should absolutely be taken advantage of because everyone wants to go home safe. Everyone, cops, suspects, everyone wants to go home safe. Citizens, they may not even be a suspect. Anyone that, when police and civilians come together, hopefully everybody goes home safe. I think that's everybody's goal, okay?
Can I clarify something? Did you
Yes,
just
sir.
say that if a civilian comes and starts and is able to calm down the suspect, that they're allowed to do that?
Potentially, yes. So for example, let's say you have a relative. I use the example of Tommy. And Tommy is engaging behavior that's dangerous. Maybe Tommy's wandering in and out of traffic, for example, and nearly caused several car accidents. And then officers are called saying, hey, there's this person who's going in and out of traffic. There's been almost several collisions. This individual is almost struck and killed. The law enforcement officer shows up. Maybe he or she isn't able to develop a rapport with Tommy, but another person comes up who knows Tommy. Tommy, you can't be going in the street. Come on, we got to go over here. If that is working under those situations to diffuse and de-escalate that situation, then certainly a civilian can help. Now, what that civilian can't do is interfere with the officer's actions. So if it goes from helping to interfering, then that's a problem. That could actually be a criminal violation. It's called Penal Code Section 148, resisting, delaying, or obstructing a peace officer in the course and scope of their duties. So those are all nuanced. If it's helpful and the law enforcement officer is working with that person, great. If they are, on the other hand, pushing the law enforcement officer back, leave my brother alone, he's not doing anything, that's a problem. Again, I'm giving you very simplistic examples.
And it's up to the discretion of the police officer to also assess the danger of the situation, right? Because if a civilian comes and says, I can help, police officer says, okay, go ahead, and that civilian gets injured, police officer could maybe get in trouble as well, right?
It could be problematic from that perspective. And let me throw another little wrinkle on that for you. Let's say an officer is arresting somebody and they're using force and an officer is not doing so well in a physical struggle. If a civilian comes and assists that officer in taking a person into custody, then they can now be sued potentially under Section 1983 because they were assisting a law enforcement officer. It's a complex analysis. There are no easy answers to any of this stuff.
A real
Yes, sir.
quick comment. I have a little bit of trouble with the word civilian. That typically applies to armed forces and non-armed forces.
Fair enough.
I think a better term is citizen, because I don't consider myself a civilian. My father was in the military. So yes, if we could please use the word citizen versus civilian, I'd really appreciate it.
Absolutely.
Thank
Yeah, I didn't, my father was in the Marines, so I understand what you're saying exactly. What I meant by that was someone who is not a law enforcement officer. I
No,
can say
I-
resident.
No, I understand.
Or-
It's just a distinction I find to be kind of important.
Meaningful?
Because, we don't.
That's fair.
You know, I understand what I'm saying. I mean, I don't like to be referred to as a civilian because I'm not, you're not military. I am a citizen, and I think that's a better term that's applicable to everybody. The police
Sure.
aren't military either. They're police.
Yeah, absolutely.
Thank you, sir.
I did not know that distinction. Thank you.
Yeah, resident or person, citizen, whatever, I don't want to offend anybody, so my apologies if I did so.
It's not an offense, I just think it's better for clarity because it makes it sound like the police are military and they're not.
Correct.
That's just my perspective on it. I don't want to see the police viewed as military or militaristic even. I think that needs to be a really good distinction.
I agree. Police are peace officers.
Exactly, there you go. Thank you, sir.
Yep. Some of the other factors you look at is number of officers versus number of subjects. If an officer is outnumbered, then they're going to have the ability to use an increased level of force than they might otherwise use. Vis-a-vis, flip that equation around. If there are 5 officers and 1 person whom they're dealing with, then those officers may not be justified in using a higher level of force because they could have, by coordination of those 5 officers versus the 1 person that they're encountering, have used less force to safely bring the situation under control. So that equation cuts both ways. Age, size, relative strength of the officers versus subjects, something else that the courts consider, and that you, as a commission, should also take a look at pursuant to this law. Specialized knowledge, skills, and abilities of subjects. I put in there jokingly ninja, but sometimes law enforcement officers may encounter somebody who has specialized combat skills. They may encounter someone who is in the military and who has a higher level of training than that officer has ever received. Or they may have physical combat skills, such as being a trained boxer, for example, or a trained martial artist of some sort that comes into play. Prior contact with that individual. What do I know about that person that I've encountered? Have I encountered them before? How did they act towards me before? Were they polite, cooperative, versus were they aggressive? Did they display a weapon? Things of that sort. Injury or exhaustion of officers, access to potential weapons. For example, clear indications, guns, knives, impact weapons, the baseball bat that I talked to you about. Another thing to think about too, folks, and I've seen this situation occur a lot of times, when officers are trying to take somebody into custody, sometimes they get one handcuff on, but they can't quite get the other one on. That handcuff on a wrist is now essentially a metal flail. And so it can be flail. It can be used to strike somebody, and it can cause serious damage. If you get hit in the face with a metal handcuff, and one end of it can swing freely, like getting hit in the head with a chain, serious bodily injury and or death could result as a result of that use of force with that type of what we will call a environmental weapon option, okay?
I had a question.
Yes, sir.
Does the person that's being arrested, if they show signs of being injured, does that at all change how police officers arrest them? I'm saying this because I saw a video, it was here in Santa Ana. There was a motorcyclist that was on the run, and I guess he ended up falling from his bike. And the video starts, I don't know what happened prior to that, but the video starts with the motorcycle is on the side, and the guy is just laying flat down. And you see like 6 officers just come to him and arrest him. Mm-hmm. I think the individual ended up passing away. But the point is that in that scenario, do the police officers have to show less, kind of adjust how they arrest individual if there's a clear sign that the individual might be injured?
So yes, that is certainly one of the factors that you need to take into account. All those things I was talking about as far as age, physicality of that person and so forth, it cuts both ways. So for example, if a law enforcement officer is encountering someone who appears to be physically frail, they need to take that into consideration when choosing a force option. Hopefully, no force at all is the goal always. So if you have someone who appears to be injured like that, legitimately so, a legitimate injury, say the officer saw them fall from the motorcycle, for example, at whatever relative rate of speed, then certainly that would be taken into account as far as what is reasonable and what is not. The officer should definitely take that into account. I'm not here to comment on any individual instance, though. Again, that's your role, folks. I'm not going to weigh in on right, wrong, this, that, and the other. But I can talk to you about what is supposed to be done and how it's going to be looked at after the fact. And that's certainly one of those things.
Thank you.
You got it. Environmental factors, we talked about lighting, rain, sunshine, that kind of, God knows we got a lot of rain lately, right? And of course, what we were just talking about, or we discussed a few times, whether the officer has reason to believe the subject is mentally ill, emotionally disturbed, or under the influence of alcohol or drugs. Certainly something should be taken into account, particularly the mental illness aspects of it, which is not a volitional choice. You know, you can choose to consume drugs or alcohol. You cannot necessarily choose if you're going to be mentally ill. That is something that simply occurs due to a variety of circumstances. So, but it definitely needs to be taken into account, all of these factors I'm talking about. Now, we talked about objectively reasonable, 20/20 hindsight vision. And you also saw in some of the prior slides discussing the Graham case that they're judged as a reasonable officer. Okay, what does that mean? Here's what it means. This is in Learning Domain 20. Would another officer facing like or similar circumstances act in the same way or use similar judgment? So, would we expect a law enforcement officer with 10 years of experience and training to act in that same manner? So you essentially have to try to put yourself in the shoes of that. And if, for example, you're in a jury trial, as I am sometimes, you have use of force experts who come in and they offer opinions about whether this officer acted appropriately or whether they didn't. And they are people who have some expertise in this area. They were, generally speaking, previously law enforcement officers, have conducted training, you name it. So they will put forth their respective opinions on either side of that issue, and you would be the ones who would judge that, okay? If the answer is yes to that question, would a reasonable officer do the same thing based with those circumstances, then that action is objectively reasonable and cannot form the basis for a civil rights violation, whether criminal or civil in nature. If the answer is no, that's not reasonable for an officer to do, then yes, civil liability and potential criminal liability flows from that officer's actions.
I have a question. So
Yes,
that
ma'am.
would apply an officer within their department or any department? Because thinking from a critical perspective, right, you can also see where the training itself has been militarized and maybe very biased. I mean, historically, we know what the research says. So is the comparison to generally how law enforcement would behave or in that department?
These are standards throughout the entire state of California. So it's not dependent
and
on
I'm
a
not-
particular department.
Yeah, I know the standards. That was not my question. Maybe I didn't ask that clearly. Is the part where it says, would another officer facing like or similar circumstances, is that definition applied to, so for instance, Santa Ana PD, are we making the judgment of how another officer in the Santa Ana PD department based on their training should act, or are we basing it in general, any other department should act?
In general.
Okay.
Yeah, that's why I was noting it was statewide training standards. So it's not confined to a particular agency. It is, would a reasonable peace officer in the state of California act that way? If the answer to that is no, then they have violated somebody's civil rights. If the answer is yes, then they acted reasonably and there's not a violation of civil rights.
How is that determined? How do they know what the consensus is, what a reasonable police officer would do?
It's determined by you. And with the guidance of, like I said, perhaps a use of force expert will come in, you'll get divergent opinions, you decide who has the better opinion, does it make sense to you? That seems reasonable to me, or that doesn't seem reasonable to me. So you're the judge of that. Whether you're sitting in a jury or in your role as a commissioner here with your oversight responsibilities. Any other questions before I get to the next thing? Now, these are a bunch of California statutes. Folks, I'm not going to read all of this to you. You have the option to do that. If you're having difficulty falling asleep tonight, I would encourage you to break out this PowerPoint, put it on your nightstand next to you, get about 6 slides into this legal stuff, and you'll go nighty-night real quick, okay? But briefly, to kind of summarize this stuff, essentially, California state law is very similar to federal law. The officer has to act objectively reasonable. Again, if you look and kind of compare some of these things, then that is the general gist of that. I do want to note a California Supreme Court decision for you. The California Supreme Court has held that a person may use reasonable force to defend life and limb against excessive force. So, there's a California provision which is the right one for you here. Bear with me. I know I cited it in here. Essentially, if you know that someone is a law enforcement officer and they are attempting to take you into custody, then you have a legal obligation to cooperate with them. Now, that legal obligation extends to the point where that officer begins using excessive force. Then your inherent right to self-defense kicks in. And that is that California Supreme Court decision that I mentioned to you, People v. Curtis. And so in other words, if you're having a police encounter and that officer, say you're completely compliant, putting your hands behind your back, you're doing everything he or she's telling you to do, and that officer starts striking you with a baton, not to get your compliance, but just because, then you have a right to defend yourself at that point in time. You don't lose your right to self-defense. You have a duty to cooperate if you are living up to your duty to cooperate with that law enforcement officer, then they are not entitled to use force because you're complying. You're complying, okay? So that's kind of a nuance that I think you need to look at. So for example, I talked to you about that Penal Code Section 148. One of the defenses to that, that's delaying, resisting, or obstructing a law enforcement officer. A defense to that, if someone is charged criminally with that, is they were saying that officer utilized excessive force, and I was simply defending myself when I fought back. I was compliant, and that's up to a jury to decide, or that's up to you in your commissioner role to decide. So that's how that plays out. Any questions about that? Yes, sir.
That's the first time I hear of that. So I'm kind of wondering if there is any other recent case that you know of that gives an example like that.
If you give me time, I can probably give you 100 citations. But that's kind of the genesis, that case there. But it's in the California criminal jury instructions. I'm not a criminal practitioner, so I don't want to get too far outside of my lane. But what I do know from my civil practice is that if an officer is acting, utilizing excessive force, that can sometimes be a defense. There's another doctrine called Heck versus Humphrey, which has, you can potentially have preclusive effect. So for example, if someone is convicted of what are called capo crimes, crimes against peace officer, all of those crimes require as one of its elements that the officer has to be acting lawfully and within the course of the scope of their duties at the time of the incident giving rise to that conviction. If they're not acting lawfully, such as by utilizing excessive force, then they do not get the benefit of that statute, and that person cannot be convicted of violating any one of these crimes against peace officers, because they're not a peace officer at the time if they're using excessive force. That's how that case law plays out. If they are, then, and that person gets convicted, then potentially if they file a claim for civil liability under Section 1983 or one of these other things, then that claim can be dismissed. Why? Because it's inconsistent with that person's conviction under California criminal law. Because necessarily if a jury found them convicted of that crime against a peace officer, necessarily that officer had to be acting within the course of their scope of their duties legally, therefore could not have been utilizing excessive force. Now there's some nuances to that as well that kind of beyond the scope of this, but that's kind of how that plays out a little bit.
And I think you may have mentioned this, and I think I saw it in our ordinance, that in that instance, if somebody's handcuffed and a police officer starts striking them, and there's other peace officers around, it's their obligation, they're obligated to stop that peace officer from doing that.
Absolutely.
If they don't, they can get in trouble as well.
It's called the duty to intercede. And the answer, if a officer observes another officer utilizing what is clearly excessive force, then they have a legal obligation to intercede and stop that officer from utilizing that excessive force, depending on circumstances. Situational. Everything is situational. You're going to hear that a lot, but it's all, you have to look at all these factors. There is no bright line rule on this stuff. So for example, say I'm standing in the back of that room right there. Let's say there's a river between us. I'm a cop, you're a cop. I see you, you have a person who you have in handcuffs kneeled down, and you are hitting them in the head. They do not appear to be resisting. Can I stop you when there's a river between us? No. But can I yell at you, hey, Officer Smith, what are you doing? Stop hitting him. That would be a duty to intercede in that situation. Let's say I'm right next to you, and I helped you put the handcuffs on that guy. And then for whatever reason, you lost your cool, and you start striking that individual, then I have an obligation to stop you physically from engaging in further use of excessive force. If not, I can be disciplined to the same extent that that officer can be. And in fact, if we talked about SB2 to a certain extent earlier, that is one of the issues there. You have a duty to intercede to prevent the excessive use of force by another officer. And if not, you can be decertified. That's one of the serious misconduct areas that we were discussing. Okay? And you jumped ahead. You're getting ahead of me with your very thoughtful questions. That's a couple of slides up here. Here's kind of California law on it. The definition of de-escalation, I think this is important to mention for a moment. De-escalation is the process of using strategies and techniques intended to decrease the intensity of the situation, essentially take things down a notch. So examples include verbal requests or commands, use of command presence, handcuffing is a de-escalation tool. Why? Because it prevents the person who is handcuffed from escalating their force. Therefore, the officer would not be required to use additional force. Positioning of the officer versus the subject. Sometimes an officer will, what is known as tactically reposition, put a car between them, for example, to attempt to gain more time, advantage, allow more time to potentially discuss things with someone. Hey, put the knife down. That's an easier conversation when there's, say, a truck between you and me, right? Than if you're standing 3 feet from me with a knife, harder conversation to have. So that tactical repositioning and use of cover and concealment can all be assistive in the de-escalation process. Let's talk about deadly force. Part of your role as a commission, obviously, is to judge use of force in incidents where deadly force is utilized by Santa Ana police officers. Obviously, this is the highest level of force. Deadly force is defined as that which has a substantial risk of causing serious bodily injury and or death. It doesn't necessarily have to be a firearm. Use of a firearm, by definition, if it is discharged, is deadly force. However, and it strikes a person, but you have in this situation, there can be other forms of deadly force as well. So for example, if an officer has a baton and is intentionally striking a person in the head, that has a substantial risk of causing serious bodily injury and or death, that would be deemed deadly force. Let's contrast, yes ma'am. I was going to say, let's contrast that from someone who is attempting to strike a person on, say, the shoulder, and because that person moved or was struggling, or it struck, glanced off their shoulder, struck somebody in the head, that would potentially be judged in a different manner because it was not an intentional volitional act or attempt to strike the person in the head. So impact weapon training zones, thighs, legs, calves, shoulders are all permissible areas for strikes with a baton. But if someone moves, the baton slips, the officer slips, strikes someone in the head, wasn't a volitional act, but nevertheless can cause serious bodily injury and or death. So in that instance, there's this, again, various ways of looking at things, no clear-cut answer. Yes, please.
So to my knowledge, AB 392, right, switched the language from reasonably to necessary in California. And also, I can see that even online on the legislator for 835A, it states that it is necessary, not reasonably, yet on the slide it says reasonably, and that's a big distinction. So I just wanted to get clarification, which one is it?
It's both. The word necessary has been in the law for a number of years in federal law.
But for California law, right, there's the goal of the bill was to switch the language because it does apply differently. And what is online on the section is necessary. And I want to make sure that we have an understanding because we're going to be making this judgment, right? Mm-hmm. And necessary and reasonably are two different definitions. So I want to have an understanding that in California law, which one is it?
I don't know. I would not agree with you that they are two distinct things. Objectively reasonable and necessary are together. And I helped write that law, by the way. I'm just telling you that. That's a fact. I helped write that law and put it into place such that these training standards have to be in effect. So reasonable and necessary go hand in hand. They're not distinct things. If it is not necessary to use force, then it is not reasonable. Does that make sense?
I mean, I disagree. I understand your argument, but I disagree.
Okay, that's fair. That's fair.
Would this now be a question to address Commissioner Pereira's question in regards to when you shoot somebody? Are you, because you just mentioned that with the baton, you can hit certain parts of the body, right? When you shoot somebody, can you shoot at different parts of the body? I think that was your question, right, Commissioner Pereira?
Is it possible? The answer is certainly yes. I will tell you that law enforcement officers are trained to shoot at center body mass in order to neutralize a threat. So I hear that all the time. So why didn't you shoot him in the leg, this, that, and the other? So again, I don't know what your background training experience is. I don't know if any of you have ever fired a firearm, more importantly, a pistol, at a moving subject. Has anyone done that? All right. Then I'll speak to you two for a moment, recognizing how difficult that is. If you've ever been on a gun range and you're firing a pistol which has a short barrel and there necessarily is more inaccurate and more difficult to hit things versus a rifle, longer barrel, more stable shooting platform and so forth, and even then, you take a high level of expertise to actually strike somebody who's moving with their hands. So why didn't you shoot the gun out of their hands? All right, a different context. Let's say you never fired a firearm at a target or something. If you've ever been to the fair and you shot those little guns where you shoot the little dolls down or whatever, did you win the big bear every time? When you had all the time in the world to sit, aim, and so forth, utilizing a rifle? If you took home the big teddy bear all the time, that's good for you. But let's take those targets and let's move them like this and try to shoot. Well, let's take a different scenario. I've got a gun in my hand and I could change direction at any given time and shoot you. I don't know if Santa Ana PD has, do you guys have a force simulator? Okay. Is it the interactive type?
Yes,
Okay.
it's interactive and the scenarios change based on the instructor's decisions to test certain areas of decision-making.
Okay. I don't know if as part of your training scope, you intend to go through the force simulator. I would highly recommend that for you because that will give you a little tidbit of what these decisions are sometimes that officers are placed in. I've been through the force simulator multiple times because look, if you're judging officers, particularly from the perspective of whether or not use of deadly force was reasonable or not, step into their shoes for a moment. That's all I would ask for your consideration. If you choose not to do it, that's fine. But to me, I'm a better judge if I've been in those shoes, if I've experienced a little bit of it. Now, I don't know, does yours have the shock vest that you wear? Does it have the shock vest that you wear? That's a fun time. So I went through the Orange County Sheriff's Department force simulator where you wear a shock vest. So every time you get shot or you get stabbed in this simulation, you get shocked with electricity. Those are I'm not necessarily encouraging you to do that, but I'm saying that is these, and I'll answer your question in one moment, sir. But that is how some of the Orange County deputies are trained, particularly the SWAT team members and so forth. They're put in that shock vest, and so they know every time that they failed to neutralize a threat before they were injured in some manner. Yes, sir.
Thank you, thank you. And since we're looking at the law and what is permissible for officers, and obviously they're going to be, judged on that. Could you give us an example just to get, kind of like an understanding from a case where an officer was found guilty for using excessive deadly force with a weapon, and a case where it was not the case, where the officer was reasonably using deadly force. So at least we can get an understanding of different scenarios. One where it was and where it wasn't.
Okay. I've got a great example. It was not the use of deadly force, but here in the Ninth Circuit, pointing a firearm at someone inappropriate is deemed a use of force, even though you're not actually using force. There's a decision called Diorley versus Rutherford, where an officer pointed a weapon at someone that the court later deemed not to be a threat at the time. And there's also another case where an officer had somebody on the ground. They were not a physical threat to that officer at the time. And the officer took his firearm and pointed it at this person's head and said some terrible things and threatened to shoot that person. That was clearly objectively unreasonable. Now, he didn't actually shoot the person, so there was no application of force, but like I said, pointing a firearm inappropriately so or unnecessarily at someone is deemed a use of force under California Ninth Circuit law. So in that case, the person was found to be outside the realm of what was legal and permissible at the time. I think he actually got criminally prosecuted for those actions. Versus where you have, when you can use deadly force is right here. When the officer reasonably believes, based on the totality of the circumstances, that such force is necessary, and it is only appropriate if they are defending an imminent threat of serious bodily injury to the officer or another person. So if, going back, again, reasonably believes, let's take the example that we discussed, the case, the Nevada County case. Let's assume now that that gun was real. That was a real gun, not a replica gun. And if I'm standing there and I'm pointing that gun down to the ground, then an officer would not be entitled to utilize deadly force against that person, despite the fact that he's holding a real gun. Because why? It's pointed down at the ground. Now, when that gun starts raising up, when does it become imminent? That there is a potential imminent threat. Doesn't mean there has to be a use of force. The officer is not required under the law to wait until force is utilized against him, deadly force. It has to be a threat, imminent threat of serious bodily injury and or death. So gun pointing down, yeah, you got a gun. Is that somewhat threatening? You come to my house, you knock on the door, let's say you're trying to tell me that my trash can's tipped over. I open my door and I've got a shotgun pointing down at the ground. Yeah, what do you want? Or would you be entitled to utilize deadly force? Let's assume you're a police officer. The answer is no. Despite the fact that I have an aggressive demeanor towards you, and despite the fact that I have a shotgun in my hand. Now, is that officer going to be understandably concerned about what may occur next? Absolutely. But would he or she be entitled to shoot that person because they said, yeah, what do you want, rudely, and had a gun in their hand? The answer is no. And if they did, then they could be certainly liable, certainly probably criminally prosecuted for murder under those circumstances.
Thank you. And
If that helps.
And I know how to, I don't have experience in terms of pointing a gun at someone per se, but I had experience that guns pointed at me by officers during protests and many different.
I've had guns pointed at me, not by an officer, but I hear you. It ain't fun.
I have a question also regarding, and it's just also to understand, when we hear about when a police officer uses deadly force with a weapon, right? And we have even seen that in some of the national big cases that have come out. We hear, the officer shot 3, 4, 5, 6 times. And, I understand that officers shoot to neutralize in the mass, right? What's the thought of the courts in terms of how many times can you shoot a person to be considerably neutralized?
So that's going to depend on the circumstances. I don't mean to be flippant about it. There is no hard rule on that. An officer is entitled to utilize deadly force to neutralize the threat of imminent threat of serious bodily injury or death. So I had a case one time. I'll give you a real world example. A law enforcement officer was struggling with an individual who had a gun in his waistband. That individual was able to get his gun out of his waistband. The officer was trying to push down on the gun and prevent him from drawing it out of his pants. The individual the officer was encountering got it out of his pants and fired the gun. Didn't strike the officer. The officer, however, fell back. He thought he'd actually been hit because they were literally fighting a foot from each other, physically fighting. The person then began running, turned and was pointing the gun at the law enforcement officers. He was shot 6 times. Why? Because he still had that gun running away. He was running away, but he's pointing a gun at the officers. He didn't fall down until the 6th shot. He didn't stop pointing the gun until the 6th shot. Now, had the officer shot him once and he dropped the gun to the ground and fell down, then you're only entitled to 1 shot because the threat is no longer there. Let me contrast that. You fall to the ground, you drop the gun. I then start crawling over towards the gun to grab it. I get my hand on the gun. I then start bringing it up again. The officer can shoot again because now you have an imminent threat of serious bodily injury or death being posed. So there is no number. In the United States Supreme Court has said you shoot until the threat has been nullified. Whether that is 50 shots or whether it is 1 shot. As long as that threat is still there, then you are still entitled to utilize deadly force. So you hear those cases. I want to point out something else for you too. A well-trained police officer can fire 2 to 3 rounds in 1 second. 1 second with today's semi-automatic pistols that are typical, or rifles for that matter. Usually the shooting cases that I have, if they're the actual shooting time sequence, which I take and measure, I utilize experts to do that, is usually 1 to 2 seconds. Many of them are less than 1 second, and 1 to 3 rounds have been shot in that 1 second period. So an officer is trained to justify every shot. They're trained to reassess the situation. But if this person is still a threat, then the officer can keep firing. Again, not my words, the United States Supreme Court has said that. So I know that I don't have a good answer for you, is what I'm telling you in a very roundabout way, other than that generalization, shoot until that imminent threat of serious bodily injury and/or death has been nullified.
Thank you, and I appreciate it. And the reason why I'm asking all these nuanced questions is because I'm trying to get a better sense of this commission will be dealing with complicated cases like that, right? And so
Yes, sir.
for me, trying to understand more of the nuances of the law and the different perspectives of the law on this is very important. So I appreciate you for answering all the questions.
Yes, sir. I'm trying to do my best, and I'm trying to keep it as unbiased as possible. I'm trying to tell you what the law is. And like I said, don't take my word for it. Feel free to find law, Google. Those are all resources where you can look up these actual cases and read the verbiage of what the courts are saying. Don't take Jim Touchstone's word for it. Read what the court is saying. I encourage you to do that. Don't take the word of anyone who stands in front of you in one of these training sessions. That's why I give you the case citations. So you go trust but verify, right? You selected me, or I was selected for expertise that I have in this area. But always do your own research, act in your own capacity as a decision maker. That's what I encourage you to do. And get different opinions. You know, you don't have to hear from me all the time. Get someone else's opinion on some of this stuff too. So that being said, be wary of the person who tries to usurp your role from you, whatever the viewpoint is, because that's not why I'm here tonight. I can tell you a little bit about my life experience, what the law says, but ultimately, if I start pointing you in a certain direction, that's where I've crossed a line, okay? Or anyone else standing at this podium has crossed a line. So, defend against imminent threat of serious bodily injury, or this is the other provision of law which authorizes use of deadly force, to apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury, if the officer reasonably believes that the person will cause death or serious bodily injury to another unless immediately apprehended. Where feasible, a peace officer shall, prior to the use of force, make reasonable efforts to identify themselves as a peace officer and warn that person that deadly force may be used unless the officer has objectively reasonable grounds to believe the person is aware of those facts, okay? That's the penal code provision. California law discusses that. So what does that mean? You may get cases, for example, which can be very controversial, where you have shot entry wounds into a suspect's back. Okay, so the bullet went in their back. And you may be asked to judge that situation. So just a couple of things for your consideration. There is also, there's a human factors training. I don't know if any of you have been through that. But let me just give you a basic real-world example that I think we've all experienced. You're driving along in a vehicle on the 57 freeway, and you glance down to see what radio station you have your car on. You glance up, and the cars are stopped in front of you. You see it, you process it, what's going on, then you brake, right? Oh my gosh, missed, didn't rear end that person. That cognitive processing time is physiological in nature. Some people have faster reactions than others, but that process has to take place in all human beings. Perception, cognitive processing, reaction through action, that takes some time. So you've got a person, say for example, you get a case in front of you, where you have BWC footage. Someone's running. Let's say they have a gun. They're running away. Running away. Let me ask you this. Can you get shot with a gun like this if you're running behind someone? The answer is yes. Is it an imminent threat of serious bodily injury and or death? So cops running after someone, they point the gun backwards like this, or they turn like this, bang, bang, and they turn back. That officer has had shots at them, processes that, reacts, and shoots back. So while he's processing and he sees, bang, bang, by the time that person's turned around, he's getting shot in the back. So there are a variety of things for consideration. Alternatively, let me flip that around on you. Let's say that the officer sees someone, bang, bang, they're facing him, then they turn around and they shoot. And now you have somebody who's shot in the back. So there's just a whole different situation. And that also goes to the other side of it. Let's say, whether or not, let's say the officer starts firing at someone for no reason. I told you earlier, you don't lose your right to self-defense if an officer is utilizing excessive force against you. So you're complying and he or she starts shooting at you. Let's assume that you are a legally licensed concealed weapon permit and you have a concealed weapon on your person. Cop shoots at you for no reason. Can you defend yourself? The answer is yes. And maybe that cop has an entry wound in his or her back. Was your force justified? People are judged by roughly the same standards when it comes to that. So things to think about when you're looking at some of these cases. And if you have the opportunity to go through some of this human factor training, that's outside my area of expertise. I've been through it, but I'm not qualified to teach that to you. I give you a very basic premise about how that could happen, but you kind of have to look at the totality of circumstances. And also recognize you'll see a lot of body-worn camera footage in your role. Body-worn cameras are typically mounted here or on the belt. They're facing forward on an officer's body. So camera seeing this, officer has eyes looking over here seeing that. So just because it's captured in the body-worn camera doesn't necessarily mean that that is the whole totality of the picture that an officer is seeing. That's what the camera is seeing. Okay? And vice versa, an officer may not have seen something that his or her camera picked up. They may give a statement saying something that's different from what's in their camera. Why? Maybe a variety of reasons. They may be lying, or they may have been looking in a different direction at that moment in time and didn't see it. So these are all things that I would ask you to at least consider when you're judging these types of cases.
And you said that an officer can't shoot somebody who's running away and they don't pose an imminent threat. What about tasering them or sending the dogs on them? Because that could be considered deadly force too, right?
No. Use of a taser is not deemed, it's intermediate force in the Ninth Circuit. Essentially all the tools that are on a peace officer's belt are intermediate levels of force, including a police canine is an intermediate, I would say, plus. No court has ruled that it's deadly force, though. If you use a well-trained canine, the canine acts according to training and policy. Now, have there been instances where the canine has caused serious bodily injury? The answer to that is absolutely yes. Absolutely yes. But it is not deemed deadly force.
Thank you.
Yep. All right. I've been talking about this a lot. Maybe I should have defined it a little earlier. Serious bodily injury or harm, what does that mean? Serious impairment of physical condition, including but not limited to loss of consciousness, concussion, bone fracture, protracted loss or impairment of the function of any bodily member or organ, a wound requiring extensive suturing, and serious disfigurement. Again, this is Penal Code Section 243F4. It's what the definition is in the law. Deadly force means any use of force that creates a substantial risk of causing death or serious bodily injury, including but not limited to the discharge of a firearm. So when you discharge a firearm, that is automatically deemed deadly force. It is the use of deadly force, whether you strike someone or not. Okay? Imminent means a threat of serious bodily injury and or death is imminent when, based on the totality of the circumstances, a reasonable officer in the same situation would believe that a person has the ability, opportunity, and apparent intent to immediately cause death or serious bodily injury to the peace officer or another person. So, for example, A peace officer can utilize, or you for that matter, can utilize deadly force to protect yourself from serious bodily injury and or death, or somebody else. So you see somebody pointing a weapon at this person, you happen to be armed, or say you're not armed, you go and tackle that person who's got a gun who's about to shoot this person. Or alternatively, an officer, let's say you have two officers on scene, the suspect that they're dealing with is pointing a gun at this officer, can I shoot? Yes, because my fellow officer is under imminent threat of serious bodily injury and or death. Certainly if they're pointing it at me, that's defense of self. This is defense of others. Okay? Justifiable homicide. Homicide is justifiable when committed by peace officers and those acting by their command in their aid and assistance, either, number one, in obedience to any judgment of a competent court, or two, when the homicide results from peace officers' use of force that is in compliance with 835A. That's that prior statutory provision that we looked at a little bit earlier. Santa Ana PD policy manual. It's my understanding you've already had a presentation on that to a certain extent. I'm not going to reiterate that. It's several hundred pages in length. Policy 300 sets forth the use of force standards for the department. Now, then you also have, I've reviewed it, it's substantially similar to the language that's contained in the statewide standards that we've been discussing for the last hour, and Learning Domain 20, how all peace officers are trained throughout the state of California. This is a provision which kind of talks about it. Obviously, officers at Santa Ana PD are expected to act in a professional, impartial, and reasonable manner. These are guidelines. As you know, any policy can only provide guidelines, much like the law that I'm talking with you here about. When you look at whether or not a policy has been violated or the law has been violated, you really have to dig down in the weeds, and it's going to be based on the situation that's before you, okay? Based on those factors that we talked about earlier. Definition of deadly force, feasible, all that stuff is consistent with state and federal law on the issue. Same thing, totality of the circumstances. It refers you back to 835A. Here's that duty to intercede. Not only is it in state and federal law, it's also in your own department's policies. And they cite Government Code Section 7286, Subdivision B. Any officer present and observing another law enforcement officer or an employee using force that is clearly beyond that which is necessary as determined by an objectively reasonable officer under the circumstances shall, when in a position to do so, i.e. I'm on this side of the river, in the prior example I gave to you, has a duty to intercede to prevent the use of unreasonable force. When observing force used by a law enforcement officer, each officer should take into account the possibility that other law enforcement officers may have additional information regarding the threat posed by the subject. Let me give you a real-world illustration of that. Let's say that I am Officer Touchstone with the Santa Ana Police Department. I am the second officer on scene. I come up, there's already another officer who's encountering and dealing with a suspect. That person is on the ground, face down, can't see his hands, and I see my fellow officer beating on that officer, or striking with the suspect, striking with a baton. I'm like, whoa, Jones, what are you doing? Stop hitting that guy. He's got a gun, he's got a gun. Officer Jones tells Officer Touchstone back, oh, different scenario. If I got a gun underneath him, which could be used to kill either of us in a moment, if that struggle turns south on us, different scenario than if that person is unarmed, not resisting, and then Officer Jones is doing that same action, different judgment. One is excessive, one is not, under those circumstances. So you kind of have to bring all those things to bear. Do you have a question, ma'am? Oh, okay, I'm sorry. Please. Yes, ma'am.
I was just curious, because this happens quite often if you read the paper and watch the news. Say a crime happens in another city, and those officers are going after that person is fleeing, say in a car or whatever, and winds up in Santa Ana, which a lot of them do, and I know we usually capture the guy they've done that for years. Who's responsible after that happens? Let's say Anaheim. Is the Anaheim Police Department responsible for that criminal even though he came into Santa Ana, or does the Santa Ana Police Department take over and it becomes their situation, or do they help one another?
That can go down a variety of ways. So let's say, for example, if someone outside Santa Ana's jurisdiction comes in the city and they're in pursuit of a vehicle, they can hand it off to Santa Ana PD if they have sufficient units and the ability to take over the pursuit. That is not common practice. Typically, Santa Ana would come in and assist potentially, but the primary pursuing agency, unless they called off the pursuit, would continue with that pursuit, depending on how far it goes, what kind of resources you have available. Where you see that a lot is CHP may, let's say you have a pursuit that's started by Santa Ana PD, goes onto a freeway, and you're now 100 miles outside of Santa Ana. CHP, if they're in a position to do so, may take over the pursuit and continue it. Or the police car from Santa Ana may be running out of gas, or a variety of circumstances. A lot of times you will see collaboration. It's not unusual to have multiple agencies involved in a pursuit that's gone cross-jurisdictional, and depending on how long it is. Typically, if it's within your city boundaries, it's going to be Santa Ana PD that's going to be dealing with the pursuit.
And they would do the arresting then and put them into the Santa Ana jail, is that correct? If
You have a
Santa Ana
jail
winds
facility?
up with it, I'm sorry.
I didn't know if the city, you have a jail facility? Is it just your temporary or type 2 or?
We have a Santa Ana jail, but the
Okay.
individuals would be booked into county. Yeah.
Okay.
Typically, Orange County Jail is where they
Okay.
would go. Usually, the municipal jail facilities are temporary holding. Depending, your level may be a little higher, or type 1, 2, and 3 are the jail facilities. And
Thank you.
yes, ma'am. Yes, sir.
And thank you, Commissioner Gorensky. That was what was going through my head right now as we were hearing this presentation. So it is common for agencies to collaborate if we deal with different, jurisdictions, with different boundaries of jurisdiction. But it's not common for, if it's within the jurisdiction, for a department to hand it off to another enforcement agent that might not be from the jurisdiction.
That's a difficult question to ask. So, for example, or to answer. So, for example, another law enforcement officer from another jurisdiction may be operating within the city of Santa Ana, doing an enforcement action or investigating a crime that occurred in their jurisdiction. They will come across the boundary. You typically have cross-jurisdictional agreements amongst your contiguous jurisdictions, which permit them to come across. Standard practice is to let Santa Ana PD know, like, hey, we're going to be in your town, we're going to be doing this, because what you don't want, you want to deconflict potential, what's called blue-on-blue use of force incidents. Say, for example, Santa Ana has a undercover team, they're not wearing uniforms, they're not in police vehicles, and they may be investigating a criminal activity in a certain household. Let's say, I'll just use Anaheim as an example, is going after someone who lives in a household next door, and they may be utilizing another undercover team to effectuate that. What you want to do is attempt to deconflict so that you don't have law enforcement officers. They see 4 people get out of the car, they've got guns in their hands, Santa Ana PD sees it, whoa, what's going on? If Anaheim hasn't notified Santa Ana PD, that might result in police officers shooting guns at each other. So, but to answer your question, usually, generally speaking and broadly speaking, if it is a crime that's committed in Santa Ana, then it's going to be Santa Ana PD that's going to typically encounter it and utilize that. Now, if you have pursuits in other areas, so for example, if another jurisdiction chases a vehicle into Santa Ana, they may be the primary enforcement officers who take that person into custody if, say, there's a traffic collision, the vehicle becomes disabled at the end because they initiated the pursuit, the criminal activity started in their jurisdiction, so usually they'll see it through. Now, whether Santa Ana PD is on scene to actually provide some kind of assistance depends. How quickly it happened, whether they had resources available at the time and so forth. If that, a broad variety of how that can go down.
Thank you.
Yep.
I had a question. I
Yes,
don't know
sir.
how much procedures differ between police departments, but if Anaheim were to come here, do they have to abide by Santa Ana policy, or?
No, they comply with their own policies, their own training. Yeah.
Don't all police departments go through the very same training, say for the state or something?
Yes, ma'am, and that was what I was talking about as far as the post standards that we've been talking about here, learning domain 20, the use of force stuff. That is statewide law enforcement officer training. Now, you have variations in departments and so forth. I will tell you that I represent dozens of law enforcement departments. Generally speaking, their policies are fairly consistent. The training is fairly consistent. Whether you have to go through perishable skills training on use of force, things of that sort, that is done by post. So they are, because officers get credit, they have continuing education requirements on this stuff, continuing training requirements. That is sponsored by post, and you have what's called a post-certified trainer. I'm actually one of those people who trains on legal issues like we're talking about here tonight. But so they have trainers, and those trainers are required to have certain levels of expertise and so forth. So for the most part, all of this training is going to be fairly consistent with some slight deviations depending on exactly how they want to handle things.
Thank you.
Yes, ma'am.
Let me take a quick pause. How much more time do we have with you, Mr. Touchstone?
I have 7.2 more hours. So I'm having dinner brought in here shortly. So. No, I'm here. So I do 4, 6, 8-hour classes sometimes. So you tell me when you want to stop. I note that it's 7:42 right now. I also note that this is not exactly the most scintillating topic. We're talking about law here. And I try to dress it up a little bit, but there comes a point of mental saturation that I pretty much concede. So.
I have no problem staying, but I do want to open it up to the commissioners. I know we're getting close to 8 o'clock, and
Yep.
Maybe other people have plans, so I wanted to open it up, and I'll entertain the motion if anybody wants to adjourn and continue this training for another time. And if we have the majority, then we can adjourn. If not, we can continue training. So does anybody want to motion for adjourn?
Mr. Chair, real quick question.
Yes, sir.
Based on what you see that's left, how much more time are we expecting?
So what slide am I on, Daniel? I'm sorry.
You're page 17.
I have 69 slides for you tonight, or for this training.
Yeah, I don't have slide numbers, but I'm on.
I don't either.
17 is what I'm showing.
Yeah, I'm probably about 20 or 22 in. So like I
About
said, this
halfway.
is, if halfway. Let's put it this way, we're not going to finish tonight despite my joking earlier. I'll talk to you as long as you want. We can kick it over to another day, and we'll finish up.
Well, I'll make the motion that we adjourn for the evening.
All right.
It seems to me we're at a good stopping point.
Yep.
I'll leave you to be the judge on that unless you think we need to continue for a few
No,
minutes.
I think we're at a good stopping point.
So I'll make the motion that we adjourn and come back to continue.
Sarah, second?
Can I make a sub-motion recommendation agreeing with that, but will not want to wait a month from now to finish the training if the commission will be open for a special session between now and then?
Yes, absolutely.
Yeah, I forgot to mention that. Appreciate that. Thank you. I agree. I don't want to wait forever. I think that we need to get it done as quickly as possible. Thank you.
And you mean just adjourn the training for right now and then still have the staff and commission comments, right?
I assume so,
Yeah, okay.
Do we have a second to adjourn? So I'm going to make a substitute motion, and the substitute motion is to stop the training, and then item number 2, and that way we can continue with the rest of the agenda for tonight. Because if we adjourn now and we vote on that, we have to stop the meeting right now. Do I have a second for the substitute motion?
I'll second.
Yeah, so if we vote to adjourn now, we have to stop now, and the rest of the items on the agenda, there's an item that we're gonna get an update for the police independent oversight director and closing comments. If we adjourn now, we can't do any of that. So the substitute motion is to stop item 2 for today, but continue with the rest of the agenda. No, now. So we'll finish the meeting, but we'll just continue with item 2 at a different time.
And we are going to do a special meeting, is that correct? We're not going to wait until our next regularly scheduled meeting, am I correct on that?
If it is the will of the commission, we will, and you all are available, we will schedule a special meeting to continue this training.
Does
Yeah.
that need to be part of the motion, or is that just understood?
You can, the chair can share that with me as staff direction.
I do plan on calling for a special meeting. Do I have a second for the substitute motion?
I'll make the motion, the substitute.
Okay.
Motion to stop discussion on agenda number 2, moved by Vice Chair Carpenter, seconded by Commissioner Perea. Commissioner Castillo-Lawton,
Yes.
Commissioner Goransky, Commissioner Mejia, Commissioner Perea,
Yes.
Commissioner Said,
Yes, thank you.
Vice Chair Carpenter,
Yes.
Chair Vega.
Yes.
Motion approved, I'm sorry. Motion approved by unanimous consent.
All right, thank you very much for listening to me tonight, folks. Hopefully it was of some assistance. I look forward to speaking with you again.
Thank you, Mr. Touchstone. All right, so we're going to continue on with the agenda. Item 3 is to receive an update on appointment of independent oversight director, City Attorney's Office.
Yes, thank you, Chair Vega. Unfortunately, as the commission may or may not be aware, the city council meeting on Tuesday was actually canceled due to the power outage and the storm. It was my intent at that city council meeting to, during closed session, to have a short presentation with the city council regarding the proposers that we have for the independent oversight director position. We were going to discuss some procedural matters that were going to play into that appointment and the interviewing process and how that would look. I was hoping to at least update you as to if there were any comments that came out of closed session that I was permitted or authorized to share, I would do so. Unfortunately, as I said, that closed session did not occur because of the council meeting being canceled. So we're going to move that over to the next regularly scheduled city council meeting. And provided there is an update that I can share beyond that, I certainly will do so.
Okay, thank you for that update. Do the commissioners have any questions? No? Okay. So now, so that concludes business calendar. We are moving on to comments. Staff, do we have any comments?
No comments this evening, thank you.
All right, so now we're gonna move on to commission comments. I'm gonna go ahead and start. So I would like to get some clarification. I know that we're not supposed to kind of go back and forth, but I'm gonna ask some questions, and if you guys want to answer, that'd be great. But if not, please email us with these answers. So, so I was looking at the Santa Ana Police Oversight Commission ordinance, and I had some questions regarding that. And they all revolve around Section 2-665, powers and duties of the Police Oversight Commission, specifically surrounding complaints. First, and I'm summarizing a bit, it says that all complaints shall be reviewed by the commission, and a copy of the complaint, tort complaints, lawsuit that alleges misconduct, regardless of where or how it is filed or submitted, shall immediately be forwarded to the commission. So my question is that system currently in place? I suppose that we haven't been forwarded any complaints because there hasn't been any. Another thing that I want to bring up is it also states that we cannot retroactively conduct investigations of complaints, which is self-explanatory in that we cannot look at complaints that were already open prior to the commission. But my question is, what date is considered to be retroactive? Mr. Touchstone mentioned that the oversight was established in 2022, so are complaints from that point forward available to us now? If not, and it's a later date, and this still may be mathematically impossible given the 1-year window of filing complaints, but if an incident happened prior to that retroactive date, but the complaint is made today, does that fall under that retroactive umbrella? So that was another point of clarification. Another one that I had was the statement that says, any complaint made against an on-duty police officer. So two things about that. So does that mean that a police officer that breaks the law while off-duty that may require disciplinary action from our police department, can the commission be involved in that? What if the incident happened here in Santa Ana and a resident filed a complaint against that off-duty officer? And then my second question to that, it says that any complaint made. So it almost implies that this doesn't just mean complaints made by residents. It could also mean complaints made by police officers. Unfortunately, we all know that misconduct can happen outside and within the police department, which I want to now say for the record that if you are a police officer and have an ongoing issue and would like to bring it to the commission, anonymously even, that we are here for you. I want to protect good cops, which I know we all do as well. I want to make sure this commission is looking out for both citizens and good police officers. The reason why I ask all of this is that we started having meetings back in October. This is our 5th meeting, and we have been active for 4 months. And trust me, I watched city council meetings, and so I know many big changes have been going on, and I certainly appreciate the staff having to work through all that. But the residents are counting on us to do our job. The taxpayers are footing over $1 million for us to do our job. The previous council unanimously voted for this, and I say this with some confidence that the current council unanimously supports this. I know our mayor is big on accountability, and there is going to come a point when the council is going to want an update from the commission. And they may ask for that a year from when we started, or maybe half a year. And after all that, if they want an update and all we have is, well, we're 50% done with training, I feel like we have failed to do our part. I know that commissioners have asked for information in their closing comments. I have asked for an item to be placed on the agenda, and nothing. I was told that it was plausible to have the survey results ready by the end of the last year, and yet here we are in February. A 2-day training session has already turned into 2 months, and we haven't even finished 25% of it. Now, don't get me wrong, I realize the importance of training. I don't want to downplay that at all. In fact, I believe it shouldn't be an option to go on a ride-along. It should be mandatory. That's just my opinion. Nonetheless, we need to be more efficient with the training schedule via extra meetings, special meetings, without compromising the effectiveness of it. But we cannot continue to go at this pace. And even though we're going through training, I want to make sure that if we can start doing our part in other duties like reviewing complaints, even if we review complaints without the ability to give recommendation due to not enough training or not having the director, I think it's still important for us to begin reviewing them. I believe that's good training, and I feel things like that are things that we can do in parallel. So my closing thought is to the staff, and I feel comfortable saying this at this point, I will like it that our commission is treated with a bit more urgency and importance. And those are my comments. So I'll start to my left for closing comments from commissioners.
Thank you for your words, and I would second that.
Thank you, Chair Vega. I appreciate the comments, and I think we had conversations on several occasions in the previous commission meetings about potentially having 4-hour, 5-hour, 6-hour blocks. I know that there was concerns with scheduling, but so I do hope that for the next meeting, perhaps even the special session that we're considering, that we finalize the next training and then we look into holding special sections for the others. I think that's the reason why we provided our availability also via email, just to see if there was room for special sessions in between. So I support those comments. My general comments are, I did receive I see now the complaints form is now aligned, so thank you to city staff for getting that up and running. So I'm hoping that there is some announcement, a social media, newsletter that to residents that this is now live, that the public can come to us with any issues that are coming up. I have certainly received some interest from, I have heard interest from residents in filing some complaints for some things that are already happening in the city. So I think that that link is timely now. The other comment that I wanted to make, and this was on mine and Commissioner Mejia's hesitation about today's training, appreciate the training that we received today, but I want to make sure that the training that we're receiving is complete and accurate, and that does not expose us to liability in the future. I think Commissioner Mejia was making a good point around the reasonable versus necessary technical term. It's a very technical term, but I believe the City of Pomona Police Department was sued by the ACLU based on that technicality, and so we want to make sure that we get the proper training and the proper technicality understanding of those situations. We don't want to open up the city to more liabilities. That's why this Police Oversight Commission was established in the first place. So for city staff, you can be on the lookout for those things, that will be much appreciated. And that will conclude my comments. Thank you.
Thank you. I agree about the trainings, and I'm very open to having special sessions that are longer. So thank you for bringing that up. And I also want to thank Daniel for the link on the website. It is officially on there, so folks can now file a complaint on the city council. So thank you for doing that. I also would like to ask the staff to review the decision about when city council voted on Lexipol. And my understanding is that there was a decision to not continue, yet last training we received was following the same rules. I would love if the staff can look into that policy and see what should be or should not be complying currently in terms of the utility of Lexipol or usage of Lexipol. I also would like to remind staff that I've asked for individual level data from Santa Ana PD, including variables that would be on use of force. I have a list. I'm more than happy to email that you as well so that you can have it. But I would still like to have that information. And also, I would like staff to clarify where, because I was looking at the ordinance and I didn't see it, so either I missed it or might be in another place, but if we can get clarification on who is considered staff, and then, like, is that city council, is that Santa Ana PD, is that city manager? And the reason I ask is because earlier, when we were informed of who decides the training, right, it's put on by staff, but I think it would be also appropriate to include commissioners' input so that we're all on board on who's providing the training and making sure that we're receiving the best training as possible. Now, my last comment is to kind of echo and remind folks my earlier comment about the differentiation between reasonable and necessary. The entire purpose of the bill was exactly that, to establish that difference because it is important. Therefore, what Mr. Touchstone's statement said earlier, that it's about the same, is actually misinformation. And as Carlos mentioned earlier, there is a lawsuit case that was filed and won by ACLU. So given that that was misinformation, given that we want to make sure that we are having the best information and accurate information to make good decision-making processes here, therefore I urge the commission to not continue the training with Mr. Touchstone, as misinformation mentioned as well as by Carlos, that can also be a liability for the city. And so we want to make sure that we don't put ourselves at risk. Thank you.
Commissioners to the right. Any closing comments?
Turn my light on. It was for Daniel. I would like to see, is it possible for you to get the list out this week to us of the dates that we gave you, like I gave you them on the telephone? So we can, I can get busy, mark my calendar and work around everything?
Yes, Commissioner, I can do that.
Okay, thank you. That's all.
Thank you. Commissioner,
I have no comments.
no comments. Vice Chair.
Yes, I have comments. I fully agree with Chair Vega and Commissioner Mejia. I had requested information also and have received nothing. In fact, I sent an email and did not get a response, which, again, to echo what Chair Vega has said, makes this seem rather unimportant. I don't think it is. I don't think the community feels that way, and I hopefully staff doesn't feel that way. So, to follow up with what Chair Vega has said, which he didn't ask for, times. I would like to see, yes, I can get this information to you by X date. That's reasonable. I don't think that's very unreasonable at all, and I would like to see that, and I would expect a response to that within close of business by Friday. For my request in particular, and for everybody else's request, I think there's been adequate time. Again, 5 meetings, I brought it up in an email, I brought it up in this meeting here, and I emailed again on that. So I don't think I'm being unreasonable. So that's what I'd like to see. And yeah, I think that's it for me. Thank you.
Thank you. That concludes comments, and with no further business before the commission, I hereby adjourn the commission meeting. The time is 8:03 p.m. The next meeting of the Police Oversight Commission is scheduled for March 14, 2024 at 5 p.m.